Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will
relevant.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dahil mihi Anglican po, service Latino.
Literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
Good morning, welcome to the Court of Public Opinion. I am the Recovery Addict. Wonderful to have you all here. I'm wearing my Santa Claus shirt today. Well, it's the closest thing I have to a Christmas shirt. Tis the season, but who's counting, right? Who's counting? Just a little over a week. I'm super excited. I get my second oldest child comes back from college tomorrow to stay for a couple weeks, and we're stoked. Everyone's so excited to see him again. It's been gone for months. All right, welcome. Good to have you all here. Red Pen tells me that Gail Pett was first in chat today, and I believe her because I can count on 0 hands the number of times Red Pen has been wrong. That means, Gail Pett, congratulations. You are, in fact, the winner of the internet. Everything IP related worldwide is your responsibility because you were prompt, you were punctual, and you said something. We just don't know what it was. I just don't know what it was. I apologize. It was gone into ether for some reason, never to be recovered. Let's see. Let's run this back up here. That's a little better. I need to just fix my studio. She said, "What? What? Me?" Gail Pett, yes, you. Goes on your permanent record. Yes, it is. Yes. You say that now, but it could get worse later on. So you never know what's going to happen with the internet. It's after all, it is a dynamic thing, and it's known to fluctuate wildly depending on who's using it and what they're using it for. So we have a ton of things.
Mike. What day is it, Mike? Guess what today is?
It's Hump Day.
Hump Day! Welcome to Wednesday. Woo! It's Wednesday. We made it. Just testing the sweet spot on the microphone where the voice sounds best. It was a little higher than normal, and I don't have anyone to give me 2 thumbs up, but I think it was worth it. I think it was 2 thumbs up. All my family is gone today. They're all out and about. My cat's ears went way back. Debbie, that's funny. It is Hump Day. We made it halfway through the work week. I ran out of breath with you. Perfect timing, Legally Blonde. Those higher octaves for me take some... A warning would be nice. Yeah, I pushed the...
Mike.
That's
what day
your
is
warning.
It, Mike?
That's basically verdict music for a Hump Day yell. So it's funny that I pretend that I don't know when I'm going to push the button, and it just interrupts me.
What day is it, Mike?
I should make it so that you guys can control that. That would be a thing. I could do that. That could be a thing. And it could... I'm thinking... Once, yeah. Anyway, all right. Mike. What day is it? Yes. I'll think about it. I'm not sure if I can make it only happen one time. Is the problem? I need to have my husband just yelled through the room. What was that? Whatever you're listening, shut it off. It's annoying as all get out. Yes, it's Wednesday though. It's worth celebrating. We made it halfway through the work week, and not everyone does. Well, I guess pretty much everyone does, but. That's too much power. That's so much power. You only get one Hump Day yell a day because I have to save my voice for next week. So every time we do it, it says, no. I'd have to figure out a way to make it only play once. Man. Okay. All right. Updates today. I think we have some birthdays, possibly, which we're going to celebrate first. And then also the Brian Walsh sentencing got pushed off a day. We don't know why. I'm guessing, just if I were to just throw this out there, I'm guessing it would be something related to victim impact statements, because we already know Brian Walsh's schedule, and he's available from now until forever. So it can't be him that caused the delay. It's something on the other side. So, but that's okay. That's all right. We have a special birthday today. 2 of them. Oh, I'm so excited. I'm sitting on pins and needles waiting for you to tell me. That'll be wonderful. Let's see who has birthday. Missed yesterday. Turned 75 yesterday. Linda K, we can sing to you today. Oh, we have Amber's mom. Kay Vixen's mom and Jana, and Linda Kay. Okay, we're going to sing to those 3 then. Let me let me get all the buttons ready and my throat. Okay, it's loosened up. It's ready. Form up, dancers, everyone. Positions, people, positions. All right, when I say we're going to sing Happy Birthday, I mean all of us, everybody, wherever we are. Please do join in singing. If you have never, you might have been here a lot of times. You might have seen what is about to happen. You might have heard it. You might know what I'm going to do. But if you have never joined in before, I ask you to do this one thing. Try me one time. Begin your day by singing Happy Birthday to somebody and see what a difference it makes. And begin your day by standing up, taking a breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. Here we go. Happy birthday to Kay Vixen's mom, Jana, and Linda Kay. Happy birthday to you. Happy birthday to you. Happy birthday, Kay Vixen's mom, Jana, and Linda Kay. Happy birthday to you. Love the snappy drums. Happy birthday. Happy birthday yesterday to Holly. 22nd birthday. We'll sing to her now. Happy birthday to you. Happy birthday to you. Belated. Happy birthday, dear Holly. Happy birthday to you. Last ad, here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Micah. Happy birthday to you. Ooh, couple ads there. There we go. We cannot add things after the song is done. So I sing the cha-cha-chas. Candace, that's awesome. Hope she has a wonderful, wonderful birthday. Jana says, you made my birthday morning. Thank you, all of you. Congratulations, Jana. Happy birthday. And here's the best part. I realize there are a million places you could be and a million people could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours, but hopefully we can turn that joy back to you. Make your day a little more special or begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Village Inn, and Cracker Barrel. There we go. Ooh. There we go. Oh, that was a lot to say. Very fast. Happy birthday, everybody. Let's do the drum solo to finish it. 2, 3, and... Beautiful. Y'all are amazing. Happy birthday. Thank you for letting us start our day by celebrating your special day. There we go. Please consider using our easy birthday form ahead of time to ensure you get a shout out on time. Thank you. We do the best we can, but I realize you also are doing the best you can, and we'll work with it. Thank you, mods, for making that happen. We're going to start our day with how Judge Middleton started his day, because we have another day of court hopping, unfortunately, until we find a really good trial. That's what we're going to do. And so, unfortunately, around the Christmas season, there just isn't a lot of people there aren't a lot of judges that are willing to just make a jury sit in a jury box through the Christmas holidays.
Happy birthday. You look good.
Those people are not out there, and thankfully so. I think that's the right call. But let's give Judge Middleton just a listen and see see how he started his day. Maybe if I don't mess it up like that, like I just did. Judge Middleton.
I think I'm about to catch a whooping.
Hold, please. Some of you said you wanted to hear the judge sing a song, and that's how he started his day, so we're going to do that.
The street, light in your head and you're dead on your feet. Another crazy day. Drink the night away and forget about everything. Good morning.
Good morning. I had the wrong courtroom.
Oh, you got me today.
I got you today. Holy cow, man.
Sorry.
No, it's sorry for you. Okay.
He was just humming himself a little tune as he started everything. You can love music and not be a great singer, and still he shares his love of music with us.
Well, we have just one guy. We have a lot of Spanish speakers today.
It looks like he retained Ives, but I don't know for sure.
I couldn't tell. Mr. Tim George is here.
Did you didn't do Mobley already, did you?
I haven't done anybody.
Oh, okay. They sent him in here. Where he went. Oh, Mobley had issues, but they kind of double-dipped him on before we was seeing he got a bowl or something. So it was another car. But it's a big problem and he doesn't have insurance and his car is immobile. But so I
barely hear her. She's at the back of the room.
See what can be worked out.
All right, I guess I might as well just get to it.
Like, I guess I have to start working today.
I don't know if I've got the live chat on or off. I hope it's off. Mr. George is here. He's ready to go. At least one defendant is here.
Mm-hmm. Oh, you only see me. I'm sorry. I was watching that. Always sees your back. I was not paying attention. Thank you, Birdie B. It's a Monday.
That one guy, they must have really been mad at him. They wrote him about 8 separate citations. 1, 2, 3, 4, 5, 6, 7.
Is Rhonda retained on that?
I don't know the answer to that.
I want to hear 7 tickets. They threw the book at him. What was he doing wrong? I'm guessing no license is one of them. They got a lot of those up in his court.
See if there's an appearance.
You guys, is there video or just audio?
I don't see an appearance.
I should pay attention to you guys a little bit better. I'm so sorry. Oh, man.
He failed to appear in January.
Yes, Simpson's still around. We will probably jump in on his court today.
Judge Patterson issued a bench warrant for him.
And an essay case.
I can't tell.
It's interesting to see the similarities between this courtroom and the one we watched, the sentencing for Mr. Rose, Terry Rose, yesterday. The similar
I don't
style,
know
the curves, probably built in the
why
same
Rhonda
era.
is listed as his lawyer. All right, we're in hurry up and wait mode.
My volume's too low. I'll just try not to talk over the judge. Let me just check. Test 1, 2. I am a little quiet. Test 1, 2. Test 1, 2. Test 1, 2. Now I'm too loud. Test 1, 2. Check, check, check. 1, 2. Test 1, 2.
All right. Miss Jackson is here from the Public Defender's Office. Mr. George is here. And one defendant is here. And the interpreter is not.
Pablo. Does Judge Middleton post his Spotify list? It was wild yesterday. That was a crazy case.
The weather is supposed to be a roller coaster. It's going to be like 35 today, and it's going to be 44 and rainy with a 40-mile-an-hour wind tomorrow. Then it's supposed to freeze real quickly, put ice on everything. Then it's supposed to melt everything for Christmas. So the sequence is not the greatest. But it may get all the snow off the side roads.
All right, since he's taking his sweet time, we're going to see if we can go elsewhere. Let's go to channel 7 for a bit. Who's this?
1974.
Very well. Mr. Birch, today's the date and time set for an informal hearing. This is a non-criminal proceeding. Nobody's going to go to jail today on this expired traffic ticket, but it's considered serious enough that Officer Bushi did issue the citation on the date in question, which was October the 29th of this year at 20 minutes past 9 in the evening. Strike that. At 20 minutes of 10, or it should say, you were operating a 2014 Chevrolet Cruze silver in color on 11 Mile Road at or near Main Street in the city of Royal Oak. And at that place and time, it was discovered, your plate had expired on your birthday, the previous April Fool's Day. So you may admit responsibility in this matter. You can admit and explain.
April Fools, you get a traffic ticket.
Responsibility will swear parties and take testimony. What do you want the court to do for you?
I like to explain.
All right, you can explain, but you do have to explain within a context. So the court is required by law to take a plea first.
Can I deny and explain?
So do you wish to admit and explain or deny?
Well, I'll admit guilt. I was
okay. So on the date in question, just stand by, Mr. Birch. You're doing fine. On the date in question, you were operating a motor vehicle in the city of Royal Oak with an expired tag, correct?
Correct.
Thank you. That was easy enough. What would you like to tell the court?
Guilty.
Well, I was driving with expired tabs with the intention of working. I was working at the time. My only source of income at the time is DoorDash, unfortunately. And I was working to get my money to get my insurance and my tabs on my car. And I got pulled over during, the time I was trying to make money to get my tabs and my insurance. So I have that now. It's just what happened was my car was in my garage. I just got it fixed and I needed insurance and tabs. And it was literally like the first week out, me driving and trying to get my tabs and insurance, and I got pulled over. And that's what happened.
All right. Thank you for that. And
that's the wrong order.
Officer Bushi, anything you'd like to share?
Nothing too much, Your Honor. It looks like everything was updated when I checked this morning, so I'm okay with dismissing.
Oh, okay, great. The officer did you a service in checking that because you'd have trouble showing us any paperwork through your audio telephone. So this matter is dismissed, and you know what to do each and every birthday. Okay?
April Fools.
Got it. Thank you, officer.
Take care. Have a nice holidays.
No problem.
Thank you. Thank you. You too. Bye-bye.
That's all you had, Officer Bushi?
Yep, I believe so.
All right. Take care. You have a nice holiday as well.
You as well, sir.
Is that all you have, Judge? Just humming a little song. He's also muted his mic.
Court call case number 25RO07504.
We're waiting for Judge
This
Simpson
is
to come in.
People of the City of Royal Oak versus Nicholas Anthony Ford. That's you? All right. For some reason, the court can't hear you, Mr. Ford.
Oh, I have to unmute. Can you hear me now?
Can you hear the court? Okay.
Is that better?
Yes.
That's 100% better.
I'd say
Mr. Ford,
90,
welcome.
92%.
Today's the date and time for your informal hearing. An informal hearing is just that. This is a non-criminal proceeding. Nobody's going to jail today on this ticket, but it's considered serious enough that Officer Moran did issue the citation on the date in question, November 23rd. This year, at 3 minutes past 8 in the evening, you were operating a 2014 Ford, blue in color on Main Street at or near 2nd in the city of Royal Oak. And at that place in time, it was discovered your plate had expired on your birthday last August. So you may admit responsibility. The court will attach a fine between 0 and the scheduled max, and that'll close the case. You can admit responsibility and explain and display an updated registration if you like, or you can deny responsibility, and the court will swear the parties and will take your testimony. What would you like the court to do for you?
I will admit responsibility. I just thought that I bought it for 2 years instead of 1, and that was it. So, yeah.
So on the date in question, you are confirming that you were operating a motor vehicle in the city of Royal Oak with an expired tag, correct?
Yes.
Thank you. And do you have your updated registration?
Yes, right here. I don't know if you guys can see.
I'm sorry, we can't. We don't want to see your registration. So, yeah. Let's see, where's your registration? Oh, yeah. I'm looking at it. Yeah, it looks good. Hold still. 2014 Ford. Mm-hmm. Yeah, okay. Yeah, looks good. It's in Detroit. Looks good. All right. Officer, what do you think?
Magistrate, can you read me that ticket number real quick for that last one?
Happy holidays.
Thank you.
He dismissed it. Sorry. I turned the audio off. that was my bad. Oh, YouTube is hard, you guys. YouTube is hard. How come your voice sounds deeper? It's the excellent Hump Day yell I did this morning that opened up the lower octaves. And I also cranked the gain a little bit. So I before it was turned down a little, but I've just added a little bit of bass. And the higher volumes.
Following case numbers,
resonates
25RO06977 and 25RO06977A. These are people of the City of Royal Oak versus Casey Alonzo Smith. That's you, sir?
Yes, sir.
Good morning, Mr. Smith. Today's the date
Good morning.
Good morning. Today's the date and time set for your informal hearing. An informal hearing is non-criminal. Nobody's going to jail today on their traffic ticket, but it's considered serious enough that Officer Moran did issue the cite on November the 7th of this year at about 20 minutes of 9 in the evening. You were operating a 2014 Nissan.
Yes.
Black in color on 10 Mile Road, at or near Main Street in the city of Royal Oak. And at that place in time, it was discovered your vehicle plate had expired on your birthday that previous November. And as well,
it's the puberty finally hit.
You
guys.
made a prohibited turn. So the citations are 1, non-moving expired plates. That's documentary, and secondly, a prohibited turn. As to both of these, you have 3 options. You may admit responsibility. The court will attach fines between 0 and the maximum, and that will close the case. You may admit responsibility with an explanation that you believe mitigates your circumstances and perhaps display an updated registration. Or you can deny responsibility and the court will swear the parties and will take your testimony. What do you wish the court to do for you?
I will wish to admit while also providing evidence of the updated the plates.
So we can perfect the record. You're doing fine. As to the date in question, you are confirming that you were operating a motor vehicle in the city of Royal Oak. You made a prohibited turn and your plate had expired November 6th, correct?
Yes.
Thank you. Court accepts your pleas and is grateful for your candor and your professionalism. Mr. Smith, what's happening?
So I wasn't aware that my plate expired on my birthday. I originally thought it would expire by the end of the month, but I have got the new plate the day after I got the ticket, and I have it right here. I'm not sure if you're able to see that.
You can hold that up to your device. Bring it in closer. Say your name.
Casey Alonzo Smith.
Officer Moran, can you see that?
Magistrate, I can't see it, but I already checked it. Go ahead and dismiss that ticket, Magistrate.
All right, that one is gone. So
can't show as a private address.
Happy holidays with respect to that one. Mr. Smith, what was happening with that turn?
Thank you.
I wasn't aware, since I was new to Royal Oak, I wasn't aware that there was a sign that says no turn on the red light. And I was quickly trying to hurry up and get to the other lane so that way I could turn that right. But in the midst of all that, I wasn't aware that there was a sign. So
okay.
So you didn't see
the court appreciates your remarks. Court doesn't have any idea what your driving record might look like. It doesn't review those before it undertakes the cases. The cases are judged on their merits alone. Officer Moran, anything you want to share?
Magistrate, can you check that driving record for me, please?
Report will now check the driving
As long as he's got a clean record, he's probably going to be let off on this one. Royal Oak's not making any money on these tickets. We're just spinning our wheels here, educating the public as to where you can and cannot park and where you can and cannot drive.
The only thing showing is this citation.
Motion that ticket amended to impeding.
Very well. Impeding traffic, Mr. Smith, is a 0-point violation, will not appear on your master driving record as a permanent mark. That's acceptable to you?
It's better than the alternative.
Very well. Your original plea subsumes a plea to impeding traffic. The fine is $175. That is payable through the pay portal on the 44th District Court website. Or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. I'm going to mark that due within 21 days. And with that, your hearing is complete. Good luck to you. Have a nice holiday.
Thanks, you too.
Taking a look at other courts that are out there right now, we've got the one we're watching right behind us, behind me. Judge McNally is not live yet. Hope he goes live
that's all I
today.
have for you, Officer Moran.
I believe
Judge
so as well,
Simpson's
Magistrate.
up.
You have a great
But we
holiday.
might be able to.
You as well, sir.
Thank you, Magistrate.
I'd be able to run down to this one real quick and see what's up here.
By testing positive for cocaine
Ooh.
and THC on November 21st.
Little
and
booger
November
sugar.
26th. And also they had a positive drug screen for cocaine and THC on October 27th of 2025.
Judge, in addition to that, on December 6th and also December 11th, she was positive for cocaine.
Judge Michaels.
So now we're up to 4 positives.
4 positives. That's
all right. Do you understand
a
that
lot.
the maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fine? I'm sorry? Mr. Fry, do you know how Ms. Pate would like to proceed with respect to these bond condition violations?
Yeah, sure, Honor. So I have spoken to my client about the violations. She wishes to plead not guilty at this time. My understanding is that she sent these tests out to the lab for confirmation. She denies using cocaine. My understanding, as far as I've heard, is we haven't gotten the results from the lab back yet.
All right, I will enter a not guilty plea for Ms. Pate on the bond.
Yes, Your Honor, this is the first pre-trial. We'd be asking for an adjournment of the pre-trial and ask for a second pre-trial in this case. It's still a pretty young case, and we're working through some evidentiary issues, and I also want to talk to the prosecutor a little bit more about potential resolution. There's another related case that has an effect on this case and getting this one resolved.
Ms. Arnold, anything that you would like to address from the people's side?
Judge, she's charged with some pretty serious charges, and 4 of the last 6 tests were positive. The likelihood that those are all inaccurate is extremely low. I think we should review her bond at this time. We also have another delivery case potentially coming that involve the death of an individual. So our concern is if she's out, 1, if she's using, she's a danger to herself, certainly. But 2, if she's using and she's possessed with intent to deliver or delivered cocaine in the past, she's a danger to others. So we would ask that the court increase her bond at this time and set this matter for a prompt hearing on the contempt and bond violation.
That sounds
if
serious.
That's what she wants to do
Delivery
if she's
with the
denying
death?
these 4 positive tests.
All right. Judge Simpson just came live, and I do want to watch him real quick. So give us just a second. I'm sorry for pulling your chain and making everyone jump around a little bit, but we're trying to get over to Judge Simpson, catch his criminal docket this morning. Judge Cedric Simpson, YouTube. There he is. All right. And by live, I mean he's not actually come out. He just turned on the camera, so any minute we'll start. Let's see who we have here in court today. Let's see, Albert Wilson. Hello, sir. Welcome. I see you. Can you see us? Yeah, I'm right in front of you. We'll stay there. Attorney Arnado is there. Jamonte Love in the bottom corner. Zeke Church, top right with the headphones. Looking good. We've got the court view, and then, of course, it looks like we have a... Is that an in-custody arraignment? Where's that at? Where's that treatment center? Not sure. Definitely doesn't look like somebody's home. And there's the judge's assistant turning on his live stream, which means he can open the door and walk in any moment now. Let's see.
I thought it was funny.
Mr. Wilson's mustache makes him look like he's frowning. It's a frowny mustache. Allie B from Tennessee, the only bidder. Allie B, you're now the internet owner.
District Court, County of Washington, State of Michigan, now in session. All those having been before the court are here. The Honorable Judge J. Cedric Simpson presiding.
Thank you, Allie. Little noisy. It always gets noisy in the morning, but it'll quiet down a bit.
I have an understanding why you brought Mr. Cook.
Yes, Your Honor.
Okay. I'll deal with that later.
Thank you, Your Honor.
It's fact.
Good morning, Your Honor. Ashley Londy Feltus for the people. Your Honor, at this time, the people would waive any conflict between this honorable court and the Office of the Public Defender. The people do not believe that any conflict exists. Do make waiver for the avoidance called out. Good morning. Well, the Defender's Office likewise does not believe the conflict exists, but if one does, we also waive.
Thank you. The court for inspired also does not believe there's a conflict either under Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus Brianna Jones.
We've seen Brianna Jones before.
Ashley Feltus for the people.
Who was that? Was that you?
That was the whole other side of the court.
That was you?
Why am I the first one you asked?
Was that what? Because you reached in your pocket.
Okay. And assistant.
And since it's not you, I would have yelled uncontrollably.
Oh, I would have just looked out. I would not have even looked out.
Yeah, that's probably true. It's okay, ma'am. Just please turn off your alarm. Okay?
And Assistant Public Defender Natalie Pate with and on behalf of Miss Brianna Jones, who appears via Zoom from the MDOC. Ma'am, can you please unmute, state your name for the court?
Brianna provided a still image.
Miss Jones, do you hear us?
Yes. Yes, I
Okay, can you state your name, please?
Brianna Jones.
Thank you. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading guilty to the charge of assault and/or assault and battery, the 93-day offense. Upon her successful plea to that charge count, one would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor. That is our full understanding, Your Honor. And prior to the plea, the only thing I want to add, I do understand it's a victim rights crime, but my client is asking if the court would just, after the plea, set it for sentencing as soon as possible, the next possible date.
Ma'am, can you please raise your right hand?
Yes.
Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes.
State your name again for the record.
Brianna Jones.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of assault and/or assault and battery. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
Understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You had signed or caused to have signed an advice of rights form. Is that correct?
Yes.
You went through that with your attorney?
Yes, I did.
Or did you say? Okay. Any questions you have regarding any of those rights?
No.
You understand that you're waiving or giving up the rights that are contained on that form?
Yes, I do.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole? You're not.
No.
Is that correct? All right. Has anybody promised you? All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, they haven't.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes, I am.
I have a problem here on my end, but we'll deal with it. On the date of June 20th, 2021, at the location of the Huron Valley Correctional Facility, Pittsfield Township, Washington County, State of Michigan, what did you do regarding a Ray Lynn Dennis that makes you think that you're guilty?
Well, it was a mutual fight, and then I continued to fight.
Mutual combat?
Back.
Okay, so there was a fight. The fight stopped, but then you continued with the assault. Is that correct?
Yes.
All right. And you didn't have that individual's permission after the initial altercation to continue that fight or to strike or hit them. Is that correct?
No, that's right.
And that is correct. Okay. And you did that intentionally, correct, ma'am?
Yes.
All right. Ma'am, I do have to advise you that if you commit any type of misconduct as defined by the Michigan court rules between the time that I accept your plea and the time of sentencing, that you would not be entitled to withdraw your plea and you would not be entitled to any sentence evaluation or recommendation. You understand that?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rules?
People are satisfied? Yes.
The court will accept the defendant's plea of guilty to this charge. 17. Pre-sentence investigation and report is ordered through probation. Sentencing in this matter We have to, and in terms of date, ma'am, I have to at least give 2 weeks for the video writ, but
Brian
the
Walsh
earliest that
sentencing
I
is
can set
tomorrow
is
now.
January 14th, 2026, 9 a.m. All right?
Okay.
All right,
mutual
bond will
combat.
continue. Thank you.
Thank you, Ron.
And
Thank
then
you,
mutual
Ron.
combat
Thank you,
ended,
Ms. Jones.
and then she kept fighting.
Court
Thank
calls
you.
case People versus Sharon Abbott.
Ashley Phelps for the people.
And you just lost your hat or something.
Morning, Your Honor. Sam Bernstein with and on behalf of Miss Abbott.
Hello, what's your name?
Morning, Sharon Abbott.
All right, what are we doing?
You're arresting for an adjournment. This is a case where Miss Foster Tucker is speaking with the prosecution about a resolution.
I think we're going to get there very soon, Your Honor.
All right. So next date,
January 7th.
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 Where's Devontae?
So it'll be adjourned January
I don't
7th,
think he's at NASA.
2026, 9 a.m. Bond will continue.
Your Honor.
Court calls case of the people versus Rick Artuso.
Ashley Phelps for the people.
Morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso. Your Honor, I'm not sure if he's on. He did call the court, I guess, this morning. He's having truck problems. I spoke with Ms. Feltus. Judge, we're going to draft a stip and order. He's on probation to Judge Conlon, and we're going to add the restitution requirements to that order of probation. And I believe the people are going to be dismissing the misdemeanors in this case. Well, once we do that and have it entered.
That's correct, Your Honor. So he only has to do one probation.
Got it.
He's been here a lot. Wasn't coming for quite some time. I don't have a problem adjourning today without him being present if the court would allow it, just so he doesn't get a warrant.
I don't have him.
He's not giving Zoom, but I can confirm.
He did.
He did.
I'll adjourn this. Well, January 7th would be my next.
I'm here, Judge, I believe, anyway.
That's fine, thank you.
Adjourn it January 7th.
All right.
January 7th,
All right. No,
2026, 9 a.m.
I'll let my client know. Thank you, Your Honor.
All right. Court calls case of the people versus Julina Azir.
Phelps for the people.
Coverall on behalf
Phone
of
lady. Go ahead.
Sorry.
Oh, lady. Oh, no.
covered on behalf of Mrs. Zier, who stands before you with her phone silenced. Mrs. Zier, please state your name for the record.
Jelena Azir.
Thank you.
Thank you, Your Honor. I was appointed very recently, so we're asking for a brief adjournment at this time.
Adjourn the matter to January 7th, 2026.
Thank you, Judge.
9 a.m. Thank you, ma'am. Bond continue.
Thank you, Your Honor.
Come talk to us.
Court calls case people versus Zeke Church.
Ashley Phelps for the people.
Your Honor, good morning to you and the
Zeke.
staff. Vincent Haysha appearing with and on behalf of Zeke Church, who's present through Zoom with no objection.
Is it just Zeke? Okay.
Yes.
State your name.
Zeke Church.
All right. Has there been an arraignment on this?
No, Judge. As to the arraignment, I'd waive formal reading and stand in mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea.
Thank you, Judge.
Thank you.
As to the pretrial, I've received written discovery. We followed up. We're looking for electronic discovery. I did also email Ms. Landy about a proposed resolution. That in mind, asking for another date. If the 7th works for the court, that would work for me. I'll make an appropriate Zoom request.
I'll adjourn the matter to January 7th, 2026, 9 a.m., or as your invite indicates. As to defendant's bond, I will set his bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possession of any weapons or anything fashioned to be a weapon. There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. I will also indicate that is there any reason you need to have contact with the victim in this case?
No, Your Honor, they don't know each other, and I'm not sure he would recognize him if you walked right into the room with him right now.
All right. And is there any reason you need to go? What is the 4095 address?
That is the incident location. I have another person as well as 2 other locations. I'm requesting no contact with the person.
Okay.
To.
Hang on a second. Let me get this one. Then
That's great.
I'm going to order no contact with Xander. I think it's Schrader.
I think so.
Okay. And who are the others?
The second
person will be Kara Christine. Kara spelled with a K, Kara, Christine, Kristine.
How many people did he assault?
A-N-E.
Allegedly.
No objection.
And the no-go to would be that 4095 Carpenter Road location in Ypsilanti.
Okay.
416 West Coruna Avenue, Corunn, both is in Nancy A, which is also in Corona, Michigan.
In Corona, Michigan.
These
Yes,
are all
Your
the
Honor.
places Zeke can't go.
And then the last location that people would request a no-go to is 4600 Britton Road,
4600 Britain.
Lot 203 in Perry, Michigan. Those are those people's addresses, Your Honor.
Got it.
Now you tell me. I thought they were stores.
Of course, no objection.
And what are the numbers with the Corona address?
416.
We don't want to give any numbers out.
416.
Just.
What I can find.
No, that's fine. So, sir, I'm going to indicate that you are not to go to those specified addresses. You understand that? Yes.
Are you there right now?
The three of them that have been stated on the record. And you're not to have any contact with Sandra Schrader or Christina or Kara Christine.
Understood.
All right. Anything further on this?
No, Your Honor.
All right. Thank you.
Thank you, Judge.
I want to see the wall behind
Court
Mr.
does call the
Wilson.
case, People versus Caleb Kashan.
Ashley Feltus for the people.
David I. Goldstein appearing on behalf of the defendant.
Your name?
Khalib Kasham.
Khalib. I'm going to mispronounce everybody.
It's spelled like Caleb.
Caleb. Pronounced Khalib.
What are we doing?
A final settlement conference room. I understand it's in February and I'm going to be gone the month of February.
Your what?
I understand that your next date is in February.
Yeah.
And I'm going to be gone the month of February.
The whole month?
Yes.
What up with you? I mean, no, I guess I shouldn't have said
Judge, when you're my age, it takes a while to recharge your batteries.
Okay, the whole month. Okay. Then our next dates are in April. So jury final settlement conference on this. Is there any objection from the people to that?
Yeah.
All right. We'll be set for April 10th, 2026, 9 a.m. Jury selection, if necessary, would be April 13th.
Yes.
April 13th, 2026 at 8:30. Both of those proceedings are in person. Bond will continue with its conditions.
Thank you, Your Honor.
Thank you. The court does call the case, People versus Shante Wingard.
Ashley Feltus for the people.
David I. Goldstein appearing on behalf of the defendant. She's approaching, Your Honor.
Hello.
Hello, your name?
Shante Wingard.
Thank you.
Same situation in this matter, Your Honor. Final settlement conference.
Jury final settlement conference, April 10th, 2026, 9 a.m. Jury selection, if necessary, April 13th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you, Your Honor.
Continue. Thank you.
Process.
Yeah, okay. Court does call the case of the People versus Jamonte Love.
Ashley Feltus for the people.
Good morning, Your Honor. Shauna Bossy appearing on behalf of Jamonte Love. Mr. Love, state your name for the record.
Jamonte Love. Thank you. What are we doing?
We're just having a brief adjournment, Your Honor.
You need a brief adjournment.
We're just having an
Adjournment
adjournment.
matter to January 7th, 2026, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Megan Maxon.
Ashley Feltus for the people.
Good morning, Your Honor. Michael Vincent on behalf of Megan Maxon. Please put your name on the record.
I'm Megan Maxon.
Thank you.
Mr. Vincent, how you doing?
I understand this is arraignment and pretrial.
It is, sir.
She stands mute to the charges.
And in every way from a reading, standing mute, court will enter a not guilty plea on her behalf. And you'd like this adjourned?
What was she charged?
All right. Will the 7th work, or you need to check your phone that went off? Okay, no.
But it is silent.
It is silent? Okay, all right. I still think it was her.
The reason you did is for cause too. That's why you picked it.
Exactly. The 7th, okay. I'll adjourn the matter then to January 7th, 2026, 9 a.m. Whereas your invite indicates. I will set the defendant's bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons or ammunition. I will also order there to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. Further indicate that the defendant is not to go to any Walmart location in the state of Michigan. You understand that?
Yes.
So,
in front of the Walmart.
It's
recreational.
All right.
You understand it does have a marijuana medical card.
So that makes it not
recreational. I tried to explain.
Yeah, thank you.
And Your Honor, would you be able to have that order, no going to Walmart, effect on my wife?
No.
Okay.
No. I'm
just asking.
You know, you were trying to do that. Garen was trying to do Costco. I'm not doing it. Both of your wives who I've met are wonderful, wonderful people. And I think they're certainly are permitted to do anything they want. And if they are spending all the money in the household, I think they're entitled. So,
well, thank you.
You're welcome.
Thank you.
I will. Thank you.
Court does call the case. People versus Albert Wilson.
Most
Good
likely
morning, Your
a
Honor.
theft
William
case.
Amadeo, P76194, on behalf of Mr. Wilson. We both appeared via Zoom. Thank you for that and consent to it. Albert, please unmute yourself and state your name for the court.
Other order. Unmute first, then state your name.
Mr. Wilson, can you unmute yourself and state your name, please, sir? You're still muted, sir.
Oh, unmute.
All right. My name is Albert George Wilson.
All right. Thank you. All right. As to the arraignment, Mr. Amadeo.
Your Honor, will waive a formal reading, stand mute, ask for standard conditions. He is 77 and not driving, Judge.
But in every way, formal reading, standing mute, court will enter a not guilty plea. Are you asking for the adjournment of this?
Yes, please, Judge. I'm just waiting on a couple more pieces of evidence. If we could have the Jan 7th date, please.
Adjourn this matter to January 7th, 2026, 9 a.m. As to bond, alleged VAC.
0.124. No crash. There is a prior from 2022.
All right.
People request soberly, Your Honor.
Over the limit.
Judge, I can briefly respond to that. He's driving at all. I understand the request for the sober link. He's not driving at all. He's basically bedridden, and he does not have any goal to drive whatsoever. So the sober link on his car would be kind of overkill. He's basically in his house all the time, not driving any vehicles.
Okay, I understand what you're saying, but I would have no way of knowing that unless I tether him to his house, that he's not doing any of that. But what I'm going to do is I'll set his bond in this case, $15,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior, possession of any weapons. I will indicate he is not to possess and or consume any alcohol, recreational marijuana, or any illegal drugs. I will sign a community corrections order. I will place him on a SoberLink testing device. So he'll need to get himself to community corrections for that device.
Yes, sir.
Thank you.
Thanks, Judge.
Court does call the case of the people versus, is it Martahada Al-Khalaf? haven't initiated.
I got it, actually. Good morning, Assistant Public Defender Lauren Kearney, on behalf of Mr. Al-Khalaf. Say your name, sir.
Al-Khalaf.
Mr. Al-Khalaf indicated to me that he went to the Secretary of State and they informed him that he had a valid license.
That he had one?
Yes.
Really? It's probably a license suspended ticket.
He does.
Dismiss.
Move to dismiss.
Any objection?
No objection.
You want your case dismissed?
Yes.
Yes, sir.
Oh,
How? Are you okay?
yes, Your Honor. He has a new case.
Of
Driving suspended.
here?
Yes, it's scheduled for arraignment, township case, 11426. It was in, warrant status, he filled out the warrant recall form. I don't know.
Oh, man. So what was the, can you see the offense date on that?
I'm looking on,
He almost
looks like September 20th.
September 20th, and this was August 29th, so this is all around the same.
But I thought it would be, well, let me see when he was arraigned.
He was arraigned
He was arraigned.
after the fact.
Okay. I'll still move to dismiss, Your Honor, but he does have another case coming.
All right.
And because he has a valid license, we'll resolve that one.
Okay. Man, just keep the license, will you? You just.
How'd he get
I'll do. Then
pulled
this
over without
case
one
is
on his
dismissed.
license wasn't on him or something?
And that, so you got rid of that one. If
How'd he get 2 tickets for having a
that warrant was recalled, the case was reset, right?
no valid license?
Right, he
when
was
you have
never arraigned on it. It was just out there.
Out there.
So, Mr.
Okay.
Rose let me know that it was pending and.
I will tell you that because Mr. Siller's going to be here this afternoon, if you let Mr. Siller, I'll have the file and can get your client back. I would have the file brought in if it can be resolved and just try to get him done and out of the way.
Okay, yeah, I think we can, and the court knows it's the standard offer on those cases, so.
Yeah, and so if that's going to be a standard offer on it, then if your client can come back, then we can get that taken care of so he doesn't have to come back in January.
I'm gonna give you a call, Mr. Alcalip, okay? So just expect a call or a text, okay?
Sounds good.
Just answer it. Be
Are
expected.
you a good driver?
Yes, sir. Hope so.
Sure. Yeah, I hope so
fine with
too.
it.
Because if I do this for you, you better not come back here. All right.
No plan on it.
Okay. Well, we may see you this afternoon then or later on. All right. Thank you,
All right.
sir.
Thank you.
Court calls the case. People versus Jeffrey Ostermiller.
Feltus for the people. Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Ostermiller. Mr. Ostermiller, say your name, please.
There he is.
It's working on the unmute part.
Jeffrey Ostermiller. Thank you.
Your Honor, Ms. Kearney and I had a chance to discuss this case. I understand Mr. Ostermiller is now on probation to 15. So at this time, people are going to be moving to dismiss this case. He can do his probation to 15.
Okay, so he's in 15, so you're going to dismiss this one.
Yes, Your Honor. No objection.
Dismiss.
Is dismissed.
Thank you.
All right. Thank you, Mr. Ostermiller. Good luck to you. Bye, you two.
Have a good day, Your Honor.
Court calls the case. People versus Candace Brooks.
Ashley Feltus for the people. Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Brooks. Ms. Brooks, please state your name for the record.
Good morning, Your Honor. Candace Brooks.
Thank you. What are we doing? I have a plea form. Is that what we're doing?
Yes, Your Honor. Yes.
Plea form indicates that the defendant will be pleading to retail fraud 3rd degree Retail fraud second degree would be dismissed. That's count one. So she's pleading count two. Count one would be dismissed.
Yes, Your Honor. That is correct, yes.
All right. Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, state your name again for the record.
Candace Brooks.
All right, you can put your hand down. Ma'am, it is this court's understanding that you're going to plead no contest to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, ma'am?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about a no contest plea I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, I do. Your Honor.
All right. The other thing that you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes, I do. Your Honor.
All right. Basis for the no contest plea?
Potential civil liability.
So, ma'am, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, I do. Your Honor.
You signed or caused to have signed an advice of rights form?
Yes, I did.
Any question regarding any of those rights?
No, Your Honor.
You understand that you're waiving or giving up all the rights that are contained on that form?
Yes, I do, Your Honor.
You understand that you're giving up your right to appeal of right?
Yes, I do, Your Honor.
All right. Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, they have not.
Anybody threaten you or coerce you?
No, they haven't.
You're doing this voluntarily and of your own free will?
Yes, I am.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 237707. Any objection to the court reviewing that report?
No, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I would have to advise you that if you commit misconduct between the time that I accept your plea and the time of your sentencing, that you would not be permitted to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, I do, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Or not? No.
And have I complied with the court?
People are satisfied. Satisfied, Your Honor.
All right. Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Defendant is referred to probation. Pre-sentence investigation and report. Sentencing in this matter will be January 14, 2026, 9 a.m. or as your invite indicates. All right, ma'am?
Okay.
Bond will continue. I need you to wait on the line. We're going to put you into a breakout room with probation intake.
Okay.
Okay? And so we can get the sentencing process started. Thank you.
Okay, thank you.
Court calls case, People versus Jocelyn Corona.
Good morning. Public Defender Lauren Kearney on behalf of Ms. Corona. Ms. Corona, please state your name.
I hope it's not the case. His channel did, all the videos disappeared.
Not checking.
So we're hoping it's still back.
Yeah, I did speak with her this week. She was going to portion of a plea form. I did speak with her yesterday and she indicated she was really ill. I don't know if that's the reason. She said she had the flu or something. She was obviously planning on being here as we had planned to enter the plea.
Any objection to an adjournment?
I don't think we have any bond violations, so I will not object to one adjournment.
All right. I'll adjourn the matter January 7th, 2026, 9 a.m. All right. Thank you. Mr. Jeff Ostermiller. You see,
Paging Jeff.
we already
Paging
dealt with it. Is there something else?
No, I can.
Were you waiting on something else, sir, or were you just hanging out?
No, I just hanging out. I can leave.
All right, not a problem. Not a problem. I just want to make sure you all taken care of.
He gone.
Court does call the
Thank you, Your
cases
Honor.
of the people versus Devontae Connor Belcher.
And Assistant Public Defender Natalie Pate with an on behalf of Mr. Connor Belcher. Sir, can you please let me state your name for the court?
Off. Unmute.
Devontae
Connor Belcher.
Thank you, Your Honor. I'm requesting an adjournment. I found out on Monday that Mr. Connor Belcher does have, I don't think the offense date is new, but some cases he still has yet to be arraigned
I'm in
on.
there, boss.
He contacted the court on Monday to do the bench warrant recalls, but I do not believe those arraignments have yet been scheduled. 2 of them are misdemeanor cases that will be coming to this court. So I'm asking for an adjournment of these files to see if we can resolve all 4.
I have 3 that are outstanding.
Yes, 3, and one's a felony, I believe.
It's pretty bad when you pick up 3 other cases before your first case arraignment. I'm guessing it does not work for NASA. That's just, I'm just putting that out.
None of the 3 I have are felonies. They're all retail fraud seconds.
Okay, Your Honor. Yes, I think it was out of the 15th District Court. There was a felony case, but he still needs to be arraigned on that. So that being said, I was requesting adjournment of the pretrials and
I'll adjourn the pretrials in this matter January 7th, 2026, 9 a.m. He needs to get all of these other matters taken care of, or at least set for hearing.
Yes, Your Honor.
7th, yes. January 7th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you, Mr. Belcher. I'll be in touch.
Is he wearing pajama? That's a pajama top, the NASA shirt?
Courthouse case, Pickles versus Daniel Worth.
What was the last name, Your Honor?
Connor.
Ashley Feltus for the people.
Daniel Worth. Defendant is not here. Doesn't have counsel.
Bench warrant.
Bench.
It's a worth with an I. Thank you so much, Ian.
Bench. What'd you say?
I think you said worth, like value. So I was thinking.
Oh,
trying to find
yes,
the
it's
space.
RWI.
Thank you, Your Honor.
All right.
I was thinking worth value too.
Oh, okay. The 14B case of well, got it.
Yes. Okay. Bench warrant will issue for defendant's failure to appear. And the reason I had the case is because of disqualification. It was reassigned to me. Bench warrant will be set in the amount of $10,000. I will give a 10% privilege on that. That warrant will issue immediately.
Is that case number 25S00429SM?
Yes.
Thank you, Your Honor.
Ready for that, Blank?
Thank you, sir.
Basically, right on time, despite parity.
What did I do?
You just don't even know now. All right, court's going to stand in recess. We'll get set up for the next block. I'll be out momentarily. Oh. Or whatever. Or whatever. That's screwed.
All right.
Yeah,
Maybe seated.
You all sit down while the judge is gone for a minute. See if we can go to 13th Judicial really quickly. Kansas 13th Judicial. There we are.
There's a mandatory minimum.
Mr. Regier.
Your Honor, this is a case where it appears to allege one count of KSA 8142. Pursuant to KSA 8149, that statute does appear to refer to a fine not exceeding $2,500 or by imprisonment in the county jail for not less than 30 days, no more than 6 months, or both such
Operation
fine
without a
and
license.
imprisonment.
All right, that's the extra provision. The sentence could be 30 days minimum up to 6 months. The fine does not have a minimum, but it could be up to $2,500.
Nike's back in court.
This
I also
might
see
be
Stranger Things in
something, I don't know if
Carhartt.
you would qualify for diversion, but the county attorney, and everyone listen, the county attorney does have a diversion program for certain offenses. You can go online and see if your offense qualifies. Go online to the address of BUCOKS, that's short for Butler County, Kansas. Again, BUCOKS.gov, and then look for diversion. And you probably can look that up this morning while you're waiting for your case to be called. You do have to apply online. There is an application fee. If you're accepted, you will pay agreed upon fine, costs, and an acceptance fee. But the beauty of it is, if you do what you agree to, they'll dismiss the charge and keep it off your record. So all of you might be interested in that if you don't have a long record and if you haven't had a lot of diversions before. So, Mr. Meredith, how do you want to proceed on the issue of an attorney? You do have the right to hire an attorney. If you cannot afford an attorney, you can apply and see if you qualify for court-appointed attorney, or you can waive your right to attorney and represent yourself.
I'd like to just waive the right of an attorney to represent myself, Your Honor.
You understand, as I said, you can hire an attorney. I can give you time to do that. Or if you want to apply for court-appointed, I can let you do that. Do you understand you have the right to do that, to hire or apply?
Yes, Your Honor.
And knowing that, you wish to waive your right to an attorney and represent yourself?
Yes, Your Honor.
Is anyone making you give up your right to an attorney by any threats or promises?
No, Your Honor.
All right, then I will have the record reflect both in the journal entry and the docket notes that you're knowingly and voluntarily waiving your right to an attorney. And then we'll proceed. Do you want to look into the diversion, Mr. Meredith? Or do you want to enter a plea of not guilty and set this for trial? Do you want to enter a plea of guilty, admitting and proceeding to sentencing? Or do you want to plead to no contest, which means you don't want to admit the charge, but you don't want to deny it and take it to trial?
April's right above us
You'd
now, so
still
we're going to watch
be
that.
found guilty, but you wouldn't be admitting it, and we'd still proceed to sentencing.
Yes, Your Honor. Depending on my situation, I have a lot going on, and I'm going to be on house arrest once I get released from custody. So it would be probably best for me to plead no contest, and if we could get it taken care of now. I don't want to end up with a failure to appear because I don't know how long we'll be in custody.
Okay.
Then I'd rather get it done today if we could, Your Honor, please.
And you could, if you are going to be in custody at a future date, you could always ask for continuance too, and that may or may not be granted. But are you sure you want to plead no contest today to register?
Yes, Your Honor. That'd be the best for my situation.
Again, you understand, you're not admitting the charge with a no contest plea. You're not denying it, but you'd still.
Yes, Your Honor.
All right. And is anyone making you enter this no contest plea?
No.
By threats, promises?
No, Your Honor.
You understand with this plea, you're giving up your right to a trial?
Yes, Your Honor.
And that, again, you'll probably be found guilty and proceed to sentencing today?
Yes, Your Honor. I would ask, Your Honor, to please consider the lowest fine I could get, or whatever you sentence me, based on I do have a lot of health problems going on, and I don't know if I'll be able to work or how anything's going to go. Maybe on house arrest.
All right, I will consider that. I will accept the plea as knowingly and voluntarily entered. Mr. Aguirre, does the state have a factual basis to support a no contest plea?
Yes, Your Honor.
Mr. Aguirre will have to give me a factual basis.
Yes, Your Honor. Where this case proceeds to trial, the state's evidence would show that a stop occurred on November 20th of 2024 involving a 2008 Porsche. The location of the stop appears to be indicated on the ticket is Southwest Highway 54 at milepost 303. State's information is that Mile marker is between Augusta and Leon city limits, south of El Dorado, well within Butler County boundaries. Besides citing the defendant for one violation of KSA 8142, the officer specifically noted no registration on the ticket. Additionally, where this case proceeded to trial, the state's evidence would show that the officer noted an Illinois state for the license number,
Did he
but
say
no
Illinois?
month or year. And the state's evidence would be proceed to trial would be to show that the vehicle was without registration at the time, as indicated on the ticket.
Very well. The state has provided a factual basis to support the defendant's knowing and voluntary no contest plea. I do find the defendant guilty of the sole count of failing to register a vehicle. Mr. Regier, does the state have any recommendations?
Yes, Your Honor. In this matter, the state is prepared to recommend a $50 fine, that the court impose appropriate court costs, and a suspended jail sentence of 30 days. The state has no objection to a 6-month non-reporting probation. Based off statements made on the record here today, the state has no objection to this case being sent automatically to collections.
Mr. Meredith, do you have anything to say? You don't have to, but you've already given me some idea about your position on sentencing.
Yes, Your Honor, that will be all. Thank you.
All right. At this time, I will follow the recommendations. Your fine, Mr. Meredith, is $50. Your court costs are $108. The total due is $158. And your sentence will be 30 days. Now, would you rather just flatten those 30 days, or would you like me to give you a 6-month non-reporting probation, and you'd have to figure out how you could report?
Would it be through a cell phone, like calling?
Possibly. Tell me what you're in custody for right now in Cherokee.
Your Honor, I'm here for counterfeiting and theft by deception.
Okay. And do you have any idea how long you might be in custody? Might you be there at least 30 days?
The judge OR'd me at this county and gave me house arrest, but I have a failure to appear from being in custody here for Paola, Kansas for a misdemeanor theft by deception.
And when do you have court in Paola, Kansas?
I will have first appearance when I get to Paola, but I do not know when that will be, Your Honor.
April's just intrigued by this Zoom camera.
Well, I'm inclined to deny probation and just have you flatten the 30 days in connection with the other cases.
I think it was
Does
theft
that
by deception.
make sense?
Do you mean like it would run like time served from being here?
Time served and concurrent.
Yes, Your Honor, I'll be okay with that.
That's what I think I'm going to do, Mr. Regier, because I don't think it makes sense to giving probation, even non-reporting. Well, maybe non-reporting. You don't think you're going to be getting out anywhere in the next 30 days, do you?
I do. I think once I get to Paola and I show them that I was here on November 25th, I think they'll release me and remove the failure to appear.
All right, I'm gonna reverse what I just said. Your sentence still will be 30 days. I'm going to give you a 6-month non-reporting probation. You won't have to see a probation officer, but you'll be on probation with just 2 conditions, maybe 3. 2. The first one is don't violate any laws for the next 6 months. If you're in custody, that hopefully will be fairly easy. And number 2 is to pay the $158, but you probably won't be able to do that anytime in the near future, right?
I will try my best, Your Honor.
Well, would you rather I just send it to collections, and then, of course, they can always collect. If you go to DOC, they can collect your money there.
No.
Okay. I'm going to order that you pay. How about, can you pay, you think, within 30 days? You've got somebody that can help you? Pay $150.
My grandparents could probably be able to help me when I get out.
All right. I'm going to order that you pay within 30 days. That may be setting you up to come back for a probation revocation hearing. But if your parents can, or grandparents, or whoever you said can help you pay it within 30 days, that's $158. It has to go to the clerk of the district court for Greenwood County, or they can pay online if they call the clerk and get the online site.
Your Honor,
Yes, Jenna.
It's Butler County, not Greenwood, in case they wrote that on a check or something.
Thank you so much. Yes, we're in Butler County today. With Zoom, I get confused which county I'm in sometimes. The days kind of run together. All right. So you'll need to call the clerk of the district court in Butler County, Kansas, because this is a Butler County ticket. And then they can give you the payment site if they want to pay online.
Yes, sure.
All right.
Do I have to serve another 30 days in custody for this?
No, because I've given you non-reporting probation.
Okay, okay.
You want the 30 days, I can take away the probation and just let you flatten the 30 days without probation.
I don't want to be here for another 30 days, Your Honor.
All right. Okay. Well,
I don't
that's
want to
the
be
order.
here for another 30
It's been a little confusing, but the sentence is, let me just go over it all. The fine is $50, court costs $108 for total due of $158. Your suspended sentence is 30 days, suspended so long as you successfully complete a 6-month non-reporting probation with 2 conditions. Number 1, violate no laws in the next 6 months. And number 2, pay the $158 within 30 days. And that's what's expected of you for this failing to register the vehicle.
Yes, Your Honor. Thank you.
You're welcome. Anything further, Mr. McGeer, from the state?
No, Your Honor.
Anything further from you, Mr. Meredith?
No, Your Honor.
All right. Thank you for appearing, and thank you to the Cherokee County Jail for making you available.
Thank you.
Thank you, officer.
Have a good day, guys.
Thank you. You too. Now we'll take up Andrew Griggs. Oh, Mr. De Hoya, who do you have?
So, Judge, I got Josh Duran, who appears by Zoom. And I need to get with Mr. Aguirre on this one.
All right. You want to take a quick breakout room while they're getting the other gentleman, or is he here? I'm looking for Andrew Griggs, but I'm not seeing him on the screen.
He's here, Judge.
Oh, there he is. Okay, I'll be back with you in just a bit, Mr. De Hoyas. Okay, we are on the record in BU 2025 TR 2145, State of Kansas versus Andrew Ray Griggs, Jared Regier for the state. Defendant Griggs appears in person at the Butler County Courthouse and pro se. Mr. Griggs, you are here per a uniform notice to appear in citation. Count 1, you're charged with speeding 78 and a 65. That is a traffic infraction. It does not carry jail time. It does carry a scheduled fine, which for 78 and a 65 would be 68. Let me double check. 78. 78
Gotta do the math,
and a
Judge.
65. The fine would be $63. Court costs $108 for a total of $171. Getting count 2, operating a motor vehicle without a valid license. That's a B misdemeanor. Maximum penalties could be $1,000 fine and 6 months in jail with probation and option. Count 3, operating with expired tag, B misdemeanor. Penalties could be up to $2,500 and 30 days to 6 months in jail. And then count 4, driving without insurance, a B misdemeanor, could be a minimum of $300 in fines and a sentence up to 6 months in jail. You would have the right to an attorney. Do you wish to hire an attorney? If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed, or you can waive your right and represent yourself. How do you want to proceed on the issue of attorney, sir?
I'd like to waive the right.
All right. Do you understand, again, that you can hire one? And if you cannot afford to hire one, I can see if you qualify and appoint one.
Yes, ma'am.
But you don't want to hire or apply?
No.
Okay. Is anyone making you give up your right to an attorney today?
No, ma'am.
All right. Then the officer will have a paper for you to sign indicating that you agree to what you've just told me.
We're going to go check out another court that Josh just found for us. This judge has the unfortunate distinction of having 2 of her 3 names be substances that are abused occasionally.
Now, Mr. Griggs, I do want to tell you that even though this is outside of my area, the Department of Motor Vehicles in Topeka can declare you an habitual violator if you have 3 of a certain combination of violations and take your record or take your license for 3 years. Do you understand that?
Yes, ma'am, I do. And I have been complying with them as well.
Let's see. Box
All right,
two
but
is
whatever
gonna be
you
7.
do
We're
today
gonna
could
jump now.
kick you
Ready?
over into that habitual status and
3.
take your license for 3 years.
Is there
You
anybody
don't
we
want to
need to
talk
see
to an
here?
attorney about that?
No, ma'am.
You do want to talk to an
All
attorney.
right.
All right. We're
So,
out.
and we are set for next Monday, December 22nd at 9 a.m. Is that correct, Mr. Foreman?
This is
That's
Judge-
correct. Okay, very good. So you've heard all that, Mr. Cook, right?
Yes, sir.
So you know you need to be back here in court next Monday.
This is
at
Judge
9 a.m.
Molly Hennessy
I'll see you then, your bond is.
Greenwald.
Thank you.
East Lansing, up in Michigan, I believe. We jumped. The ump says jump, we jump. We're still keeping an eye on April, right above us there.
Ayden.
Got quiet. April is, what are you doing, April?
And Mr. Mayor, I'm next going to call the last co-defendant. That would be people of the state of Michigan versus Anthony Pfeiffer. Case number 251083 FY, and we're here for a preliminary, a probable cause conference this morning. And good morning, your appearance for the record, please.
Good morning, Your Honor. Terry Harris, people.
Good morning, Judge. Ms. Martinez on behalf of Mr. Pfeiffer. Ms. Martinez, and hello to Mr. Pfeiffer. So this is a probable cause conference. This is the last of the 3 co-defendants. Mr. Bear, how would you like to proceed here?
Your Honor, again, a plea offer was extended to the firm, not exactly to the specific defense lawyer, but the plea offer is MCL 750.356A2B1, break manner, vehicle to steal property, $200 or less, plus restitution to the victims of the alleged break-in. At this time, I've had no communication with the defense attorney, direct communication. I have no idea if she's accepting the plea or not.
And Ms. Martinez.
Hey, Judge. At this point, I would like to ask for adjournment. I have only received the police report, so I haven't retrieved copies of a lot of evidence in the case. So we would ask for a board adjournment. I will be out of the country for the next 3 weeks. So I believe 4 weeks would be enough.
Everybody in this court is on
And,
camera twice except for Heather.
This is a co-defendant case where there's interests of judicial economy and efficiency to have the case consolidated for preliminary examination, as the court rule strongly suggests we should do. The other co-defendants, I don't know how much sooner they got discovery, but there's no discovery issues with them, and they'll be all ready to go on Monday. Can you tell me why you were differently you were in a different situation?
We are conflict counsel, so.
So is another co-defendant.
Okay, well, we only received the. So
let's talk about what else is there, Mr. Bear. And I don't know, Mr. Foreman, if I'm able to recall you and Mr. Carter. Is Mr. Carter still here? Thank you.
Your Honor, for the record, I'm showing, just to clarify the record, we sent discovery on the 15th, which would have been Monday. So that
2 days
confirms
ago.
that. Let me check 1 moment.
She says she doesn't have discovery.
There
are 3
there
people
are
charged.
photographs, Your Honor. There's also body cam. Ms. Martinez, did you receive any of that?
I did receive some of the pictures with the police report, with the initial evidence stuff, but I don't have any body cam videos.
What's the procedure for getting body from your office?
If it's available, Your Honor, we make it available with the initial discovery pack. As far as I know, if it wasn't sent over, I'll have our discovery team look into it.
Okay, it doesn't require the defense attorney come to the office and pick up it.
Only for CSAM and stuff, Your Honor, not for this.
So let me just ask, I do have the other attorneys, Mr. Foreman is here. And Mr. Foreman, on behalf of Mr. Cook, have you received the discovery Mr. Bear outlined?
I have, Your Honor. There's really significant video. There's, I think, somewhere in the line, somewhere between 20 and 30 total videos between body camera and surveillance video and things like that. That's provided to my office at the time I received our initial discovery.
Okay. And it just came with the normal procedures, discovery packet. Is it Axion or what did you?
Yeah, it's evidence.com.
Okay. And are you familiar with evidence.com, Ms. Martinez?
Not that I've never said what you're doing.
Okay, so I think that might be the issue. Mr. Carter, have you and your client received all the discovery the prosecutor just outlined?
I don't know what I don't have, but I did get I got the link to there's two links that are sent out. The link that has the paper and some photographs that I did receive. And then there's a separate link that normally comes across, which is evidence.com. And I did receive that link. It takes some time to download it at times. But yes, I did receive those links. Now, hopefully all the videos are in them.
Of course. We just were saying Ms. Martinez is saying she doesn't have those videos. Can you check your email? Did you receive the link? And just Mr. Carter and Mr. Foreman, you both indicated that you would like to leave on for our preliminary examination on Monday. I trust that's because you believe that you'll be prepared and ready to go on Monday. Is that right?
Oh, I will be prepared and ready to go. My client is out on bond, so if there's an adjournment, I don't know if I necessarily object to that. But,
okay. But you can digest and prepare and be ready for rerun on Monday.
Yes.
And Mr. Foreman?
We're in the same position as Mr. Carter stated.
Ms. Foreman can hear me, right? Sorry.
Very clear.
I will note, Judge, that the court rules do provide that one of the defendants is unavailable for preliminary examination, and as an exception to the strong presumption to run them all together. So if one of the co-defendants is not available or counsel is not available, I think Mr. Carter and I would be prepared to proceed still on Monday, but of course then that would be in question for Mr. Bear as to whether we would want to run two preliminary examinations here.
So, Ms. Martinez, as you're looking through that, I'm inclined to deny your request just from the information I have before me. I think that there's just your perhaps unfamiliarity with the evidence.com and the way that the Indian County Prosecutor's Office sends discovery. That I think is likely to be the issue here. Mr. Bear is going to confirm that it was all sent, but in the meantime, we do have two co-defendant attorneys here. I mean, is there any reason why, Mr. Foreman, could you just go over what you have with Ms. Martinez here, at least preliminarily, so she can see what she's looking for?
I wouldn't be able to provide it to her. The prosecutor's office has pretty strong feelings about that. But I can at least go over with her the context of what I have.
Absolutely, and even just walk her through technically how you access it.
Sure, Jim, that's not my clerks. I'm not sure I have the answers there, but that's what we can do.
Your Honor, just for the record, there is a note here on the 15th. When we sent discovery, there were also 28 files of Axon that were sent out. I could certainly have our discovery reach out to, well, the appearance is, I believe, her boss, Mr. Jack Rucker. If she perhaps gives us a direct appearance, we can send that to her directly.
It's hard
to see. So, Ms. Martinez, your request for adjournment is denied. For the reasons that we've stated. I think that you do have discovery, you just need to access it. And what I'm told by other, two competent attorneys, and I know you are too, is that you absolutely will be ready for examination.
I am leaving the country tomorrow.
That's a different, just,
yeah. But I will be gone for 2.5.
And Mr. Rucker has put in an appearance, and is there no one else from the firm, including Mr. Rucker, who?
I'm emailing him right now.
Okay, we'll stand in recess and we can recall the matter. We have these two other attorneys who are kind of waiting in the wings because, we're not quite sure what we're doing with your case. So as soon as possible, and, my strong inclination is to deny your request.
I just got a response, Judge. He said he can cover it.
So we're continuing for all three cases to exam on Monday, and we can address any issues at that time. So what all that means, Mr. Pfeiffer, is you need to be here in person in this courtroom next Monday at 9 p.m. Okay, your bond is continued. I'll remind all three attorneys that all three clients need to have their fingerprints taken, and that needs to happen by the time of the preliminary examination. I have orders here.
I want to follow this one. Sounds like a robbery thing or a break and entering. Is that what it was? Interesting. Monday. We'll have to go back to this court, Josh. Can you remember that?
Well, do they come downstairs here? Nothing.
MSU. Oh, it's an MSU case.
If the judge is going to turn off the live stream, we're going to go back to April.
Yes.
Waiting patiently, and let's check out April. Let's see. Should be starting soon. How are you doing, April? I think she's just trying to find her best angle. The one eye look is a common one that's used, but I thought I'd put up the court hopping so that people know what we're doing, so there's no expectation that we're supposed to start a case or something. Also, check the pinned message. The Brian Walsh sentencing has been delayed until tomorrow. It'll be tomorrow morning for that, so Thursday morning. There's a possibility that I know there's a cruise ship custody hearing involving the mother of a girl that was found dead on a Carnival cruise line, where the stepson might be the suspect. It was a strangulation by bar hold situation. So that's a possibility for today as well. Thank you, Tony, for that one. Let's see. A couple things going on right now. We've got Judge Webster doing her thing quietly, apparently.
We will now take up Duran, BU on the record in BU 2025 TR 1266, State of Kansas versus Joshua Samuel Duran. Please announce appearances.
Jerry Regier on behalf of the state.
Your Honor, Mr. Duran appears by Zoom along with counsel Jorge De Hoyos by Zoom.
Mr. De Hoyos, did you say you needed a breakout room with the prosecutor?
No, Judge, I need to speak with Mr. Aguirre sometime in the near future, but not at this court hearing. I'm just looking to set this thing for my other traffic cases on 2/18 at 1:30. I was hoping to match that up.
Okay, we have one speeding charge. Do you want to set that for trial?
For the February 18th date, yes, Judge, for now.
And February 18th, Jenna, is that a trial date?
We have to go back to this other court.
Yes, Your Honor. And Ms. Sumner, is there any part of this agreement
Young
whereby
Kim.
Mr. Kim would be admitting responsibility to a civil
Is that his
infraction?
homework
I
in his
know he's
background?
posted a $500 bond.
So we can clarify with Mr. Bicklin, but I would have the the court retain that $500 bond, but no criminal charge or civil infraction would issue, just as the bond would be retained.
I don't know if I can do that if the charge is not laid and there's no other admission of anything for me to assess fines and costs.
He's working on his homework in the background. I think that is some next level math or
Mr.
stats or
Bicklin, would you be willing to go to a littering civil infraction?
Yes, that would be fine. As
Okay.
long as the misdemeanor retail fraud is dismissed, a civil infraction would be sufficient. Yes, that's fine.
Going from misdemeanor.
So then the agreement is
Retail fraud
that
to
the
littering?
city is moving to dismiss the misdemeanor retail fraud, and a civil infraction for littering will commence, and that'll be at $500. Mr. Kim has posted a $500 bond. That bond will be applied, And so, thus this case can be closed. Is that amenable and accurate for everyone, Ms. Sumner?
Mr. Kim's like, wait, I have a
And
question.
Mr. Ficklin?
Yes.
Very
Yes,
good. Mr. Kim, did you hear everything that the lawyers and I just talked about?
So, sorry, I just kind of wanted to make sure I understand correct. So my understanding is that there's a civil infraction fee of $500, but the bond money that was I guess that I submitted before will be used for that payment, meaning that I don't have to pay any more money, right?
That's exactly right.
You won.
Okay, and also importantly, Mr. Kim, the misdemeanor that you pled to last year is now going to be dismissed, so that won't be on your record any longer. And I'm told that's because you have been doing good things with your life,
like making
including staying away from any contact with the criminal justice system. And so you earned that through your dedication and commitment to being compliant with the terms here. So in that way, I commend you, and I wish you good luck. Anything further from anyone else?
Yes, please explain the graph.
Thank you. Okay,
Nothing from the defense, Your Honor.
Mr. Kim, I have an address for you on Baldwin Drive. A good address?
Yes, that is good address.
Okay, that's where the judgment for the civil infraction will be sent. Thank you all and good luck.
Thank you.
Thank you, Your Honor. Thank you. Have a good day, everyone.
Just for clarification, does the court need a form?
Explanation
I'm
on the-
seeing shaking
on
of
the
a head,
graph,
no, so
please.
thank you.
That graph is
Oh, also, I'll be getting a letter, I guess, with the record showing the dismissal of the charge by the mail.
your lawyer's
You
gone,
were,
buddy.
yes, you will. There'll be an order of dismissal and then the judgment for the civil infraction. That'll be sent to your Troy address.
Sounds good. Thank you.
Here.
I think the graph behind him is the
can
recipe
leave
for
now,
elephant
or-
toothpaste.
You can. Thank you, Mr. Kim.
Bye-bye.
It's a closely guarded secret up until now. All right. I'm sorry. We just had to jump. I saw that graph. I'm like, I'm sorry. I need to see what's going on there. Now we can go back to.
Now calling the matter, this is the people of the state of Michigan versus Robriana and Jesse Lopez. This is case number 24420 SM. We're set for sentencing today. Here's the record.
Good morning, our trigger is prosecutor for the people.
Sentencing.
Good morning, Dr. Josephine on behalf of Ms. Lopez, who is president of Mountains.
Thank you. Good morning, Ms. Lopez. We're here for sentencing today. The court has received a pre-sentence investigation report. Mr. Beard, did you receive and review that report?
Yes, Your Honor.
Did any additions, deletions, or corrections?
I do not, Your Honor.
And Mr. Gain, did you and Ms. Lopez receive and review that report?
Yes, Your Honor.
Do you have any additions, deletions, or corrections?
I had an update to her appointment.
Absolutely.
So she's currently employed at the Amazon warehouse.
It's hard work,
working
but it's good money.
approximately 36 hours a week.
Yeah, that's good news. Lopez, and I have made that change to the base page of the report.
36, so you don't have
With
to provide
that,
health insurance.
Mr. Bear, elocution on behalf of the people and victim.
Your Honor, I have no statement from the victim. Last I talked to her, she said she had, quote, moved on from the incident. That being said, the people who have reviewed the recommendations of the report, we find them very fair and thorough, and we leave sentencing to the discretion of the court.
And Mr. Yang, elocution on behalf of Ms. Lopez.
Thank you, Your Honor. I just support grants Ms. Lopez the IDA. It appears based on the report that she is eligible for that, and I say grant that. I did explain to her that she still has to earn it, just because she grants it, she still has to complete a successful term of probation. I'd say you waive as many of the fines and costs as possible. She is indigent, as I'm competent counsel for her, though she does have employment now, she's just recently was able to obtain that. So I asked the court to take that into consideration. Additionally, I know the recommendation is for 12 months of probation, and she would be eligible for an early discharge for this, but I know bond is effectively probation, but I asked the court to take that into consideration. This case was from 2023. She's been on bond for a little over 6 months or so. So I asked her to take that into consideration as well too. So I think she's learned from this. The conversations we've had is kind of mind your business type of thing and stay out of other people's business. So I think that is the goal here, and
Good
I think
advice.
she's going to be a great candidate for probation and higher probation. Thank you, Your Honor.
That's good to hear. Thank you very much.
That Nunya stuff.
And
Nunya
Ms.
business.
Lopez, what would you like to tell the court before I close?
Nothing much. I'm just trying to get past it.
Understood. So if I may just ask a few things, I always want to make sure when I need to make a decision about the HIDA status, that the person, understands what HIDA is and what is the benefit. So I know you and Mr. Yang have talked about it. What's your understanding about what HIDA means for you?
Basically, that you guys are gonna drop some charges or something.
Sort of. I mean, it definitely has to do with a benefit in terms of the charge. What it means is that the charge, which you are already convicted of, but remember, is and it's an offense of assault battery, and it's a misdemeanor offense. It is an assaultive offense on its face. It's called assault and battery, and it's the type of thing that could be detrimental to someone for their future. So what HIDA would allow to happen is that would become a non-public conviction. So that when you go to your next job, they would not be able to see that you've been convicted of assault battery. And same thing if you want to go to the bank. You get a
Happy
loan.
Hump Day,
Or if
happy
you went
holidays,
back
Merry
to
Christmas
school,
to all. Thank you.
Those types of institutions would not be able to
Congratulations on
see
12 months.
this conviction. So do you understand that and the benefit to you? Yes. And you're a young person and you've got a big life ahead of you. So that's why I'm strongly considering granting you this special status. And I just want to make sure that you get what it's for and also understand the benefits so you can be motivated to succeed.
All right. Thank you,
Which
Your
you
Honor.
do, like Mr. Yang said, you do it to earn it. And you earn it by completing your probation
being good.
successfully. Okay.
Hang on. We're getting
Ms. Lopez,
getting a tour
when
of
you
the
talked
house.
to our
from April.
probation officer, you indicated, your goal here would be to help you make better decisions and maybe work on your GED and better employment opportunities. Yes. Those all seem like really, really admirable goals and things that we would want to support you with. Mr. Yang does know this is a somewhat older case and you have been on bond for some time. So I might take that into consideration in considering the length of time. A 12-month term of probation is a fairly lengthy term of probation. So I will take that into account, but I think that the terms and conditions are otherwise appropriate and tailored to you and to your goals. So with all that, Ms. Lopez, it is the sentence of this court that you shall serve an 8-month term of probation and you'll report as directed by your probation officer. You need to complete the soldier behavior program at the direction of your probation officer and follow all recommendations. You also need to complete a moral recognition therapy program at the direction of your probation officer and follow all recommendations. You shall complete the GED program at the direction of your
Get
probation
your GED.
officer.
That's a good one.
I know that term may be unreasonable, perhaps even impossible to complete in the 8-month term, but what I'm looking for, and I'll make this, is that you are making good faith efforts at completing your GED.
All right.
Are you able to assure that he will be here on time for every future hearing if I let him appear by Zoom?
Yes.
Would you prefer that over driving him down every day or every time?
We could drive down, and that's fine also.
All right, if you have no problem driving him, then I will grant that you can drive him down, then if that's if that's no problem to you.
Yes, that's fine with us. Thank you.
What is that, about 30, 45 minutes?
Like around 2 hours.
2 hours by turnpike?
Yes.
Okay. I didn't think it was that long, but if you don't mind doing it, that'll be the order. Appear in person, and you won't have to worry about having problems with your Zoom connections.
All right.
Thank you.
All right. Thank you. You have a good day.
Ms. Waters, thank you. Ms. Waters, did you hear me talking to him about his hearing being March 11th and how he can look into diversion, hire an attorney, or apply for court appointed?
Yes, I heard all that.
All right, thank you. If you could help make sure he does that, I'd appreciate it. We will be in recess on Waters. Mr. Waters and his mother are excused at this time.
Hey, Judge, now we could bring Grayson Kane in. He's back.
Okay.
Grayson Kane. Grayson Kane, excuse me.
With K.
We've got Emily. We've got April and Emily. Emily looks like she has. What's she playing with here?
We are on the record in BU 2025 TR 1439, State of Kansas versus Grayson Michael Kane. Jared Regier for the state. Defendant Mr. Kane in person and pro se. Mr. Kane, you are charged in count 1 with speeding.
How fast?
86 and a 65, and that is a scheduled fine. It does not carry any jail time.
So 21
but
over.
if you were to be convicted for speeding, allegedly speeding, if you were to be convicted for speeding 86 and a 65, your fine would be $114 plus 108 court costs for a total of $227 on that matter. Then in count 2, you're charged of operating a vehicle without registration or with expired tag, both counts 1 and 2 happening in Butler County on June 19th of 2025. That charge, the vehicle is a misdemeanor, and it carries a fine up to $2,500 and a possible sentence of 30 days in jail up to 6 months, although probation is an option. You do have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed, or you can waive your right and represent yourself. How do you wish to proceed on the issue of an attorney?
I'll waive my right.
Okay, how old are you?
25.
25. You understand, though, that you can hire, and if you can't afford to hire, I can apply, possibly appoint an attorney?
Yes, ma'am.
And knowing that, you wish to waive your right to an attorney and exercise your right to represent yourself, correct?
Yes, ma'am.
All right, the officer will have a form there called a written waiver of attorney for you to look at. If you approve it, sign it.
Put April over here.
Read and signed, Judge.
All right, I will have the record reflect that the defendant has knowingly, both in writing and orally, waived his right to counsel. Now, Mr. Kane, I'll ask you how you plead to these charges. You can plead not guilty to one or both, and we can set the charge that you're pleading not guilty to for trial at a later date. The burden will be on the state to try to prove beyond a reasonable doubt if they can. The second choice to plead you have is to plead guilty. That means you will admit one or both of these charges and proceed to sentencing today. Or you can plead no contest, which means you don't want to admit these charges, but you don't want to go to trial. You'd still be found guilty even though you weren't admitting them and proceed to sentencing today. A final option would be to apply for the county attorney's diversion program, whereby you agree to make a payment towards your fine and costs plus diversion fees. And if you do whatever they tell you to do, such as provide proof that you've gotten your registration or tag renewed, they would agree to dismiss the charges and keep them off your record. But if you're interested in diversion, you do have to go online to their program at bucoks.gov and see if you qualify, read through the requirements, see if you qualify, see if you want to accept the terms, and if you do, you apply online. If they approve you, then they send you a contract in the mail, and you sign that contract and send it back with any fees required. So how do you want to proceed on the issue of plea or diversion?
I'd like to apply for diversion.
All right, I will enter a not guilty plea. This has to be pre-trial diversion, so not guilty. And we're going to set your trial. What time do we want to set his? Is it 3:11?
Yes, Your Honor.
I think I told Peyton Waters to be back at 9. Is that what I said?
Mm-hmm. You did.
Yes, Your Honor.
And I probably should have said 1:30.
Are you wanting to set them on a bench trial date, Your Honor, or are you wanting to put them on a Wednesday morning? Because I put Waters on a Wednesday morning.
Let's put him on a Wednesday morning because he may not want a trial.
Where's Kim?
Okay, so that
What
would
court is
stay the
Kim
same,
in?
March 11th at 9.
Yes, let's do that. All right. So, Mr. Kane, if you're interested in diversion, don't wait till your court date. You get online today and see if you qualify and if you want diversion and get it done. Get applied, get it started. Don't wait until the week before your court case. Say, oh yeah, I want to look into that diversion. That won't give you enough time, and that'll just delay your case. Don't do that. So be back here. I'm ordering that you be back here March 11, 2026 at 9 a.m. unless you're diverted. If you're fully diverted, then the county attorney will tell you you don't have to be here because it's a diversion from the court process. Any questions about any of that so far?
No, ma'am.
Now, did you sign that $1,000 cash or surety bond I ordered you to on September 10th?
Yes, ma'am.
Okay, you won't have to do that again. I will continue that bond with the added condition that you either be diverted or be back here pursuant to that bond. Do you understand that, sir?
Yes,
Are you
ma'am.
having questions about it?
No, ma'am.
All right, then thank you. We'll either see you or your diversion paperwork on the next court date.
Derek. Okay, next one up is last name Barry, starting with a B, first name Derek.
What happened to Manjeet Singh? Did I take up Manjeet? No, he's still waiting. Okay. Maybe we can get you after this one. So last name of Barry, first name is
Derek.
Derek. Thank you.
We're going to jump to Simpson as soon as it goes live. We're sort of following what's up with April.
On the record in
I'll save
2025
Judge Webster so
TR
we can come back to that.
2041, State of Kansas versus Derek Marshall Barry. County Attorney Jared Regier for the state, defendant Barry in person and pro se. Mr. Barry, you are issued a citation to be here today. Count 1 alleges that you were speeding 80 in a 65 mile per hour zone. That is a traffic infraction. It does not carry jail time, but if you were to be convicted, your fine would be $75 plus $108 in court costs. On count 2, you're charged with failing to wear your seatbelt. That's considered an infraction with a fine only being $30. And then count 3, no liability insurance is a B misdemeanor. If convicted, your fine would have to be at least $300, but could be up to $1,000. And you could be given a jail sentence of up to 6 months, but probation is an option in lieu of having to actually serve it. It's often suspended with probation. So those are your charges. Those are your possible penalties. Now then, you do have the right to an attorney. You can hire any attorney of your choice. If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed, or you can waive your right to an attorney and represent yourself. Another option might be the county attorney's diversion policy, where if you did certain things and paid certain amounts, they would dismiss all charges against you. But you would have to go online to their website at bucoks.gov and see if you qualify for diversion and see if you want to apply for diversion. If you do, you'd need to turn in your application online with any fees and go from there. But again, if you apply and you're accepted and you do what you're told, they will dismiss all of these charges against you. Are you interested in diversion or an attorney, sir?
You had proof of insurance. I have proof of that I had insurance that day.
Who's the person giving you advice there on the side?
It's my sister.
All right, well, unless she's your lawyer, you need to talk for yourself. But,
Right.
but she brings up a very good point. If you had proof of insurance, if you had insurance at the time of the stop on September 1st, but you just couldn't find it when the officer asked for it, if you get that in with your diversion or to the county attorney, that will be dismissed most likely. Do you have the proof with you today?
Yes, ma'am.
All right, you might want to take that down to their office and leave a copy before you leave the courthouse today. But as far as the rest of the matters, do you want to look into diversion?
Yeah.
Do you want to, okay. You're not going to hire an attorney or apply for court appointed today?
No,
Or
ma'am.
are you? Okay. All right, then the officer's got a
Hold, please.
form
We've
there
got
to
a,
show. You'll need to read and sign.
Hello.
Hi, good morning. This is Leonie. I am calling with the TV Tech publication on a recorded line to send this year's complimentary copy to look in that video. So we're just making sure the information on file here is up to date. I will be brief, okay?
I need to update the company name. Are you there? Hello? Why'd she hang up? That's my magazine. That's the one I watch.
Okay. Yeah, sign it. Read and signed, Judge.
All right, the record will reflect that you have knowingly and voluntarily waived your right to counsel.
That was a
And did you
legitimate
say
call.
you did or did not want to look into diversion?
Yes, diversion.
All right. And you've got the website to do that. They like you to do all
Looking
of that
Back
online
Video
if
was
possible.
my old company name.
Okay, yeah.
We were making historical
And your
videos
next
for
court
family
date
members.
will be March 11 at 9 a.m. You must be back here by Zoom unless you are diverted, Mr. Berry, and that is plenty of time to be diverted. Get that application in today. They'll send you an agreement in the mail. Look for that. If you don't get it in a couple of weeks, call the county attorney. If you get it in the mail, sign it, send it back with whatever funds they tell you to, do what they tell you to. It's possible you could have all of this dismissed before March 11th. And even if you don't get it all done by March 11th, if you've got the application on file or the agreement on file, you won't even have to come back and see me March 11th.
Yes, ma'am.
So don't wait until the week before court. Get in there today and get that submitted.
Yes, ma'am.
Or at least very soon. All right. Anything further, Mr. Regier?
Your Honor, there is still the issue of booking and bond, and and to put the court on notice, the state is requesting a brief recess of approximately 2 minutes, as well as the opportunity to be heard on the issue of bond.
All right, we'll take a 2-minute recess and come back and discuss bond, since you apparently have not posted a bond yet, Mr. Berry. And I'm required as a judge to order anyone with an A or B misdemeanor or higher to get picture and prints taken and potentially post a bond. So we'll take a 2-minute recess and come back and discuss that again.
Mr.
Thank you, Your Honor.
Regier will
You're welcome.
enforce the law here. 2-minute recess. Meanwhile, I think we're going to be jumping to Judge Simpson's court, where we've got all sorts of things going in the background. Let's take a look down here. Oh, that's the wrong one. Where were we? We were right here. We were here, and we're going to box 2. There it is. Who's this? Sincere Godwin. He's got the Christmas lights up, the hats on the wall. Rodney Lilly, April with 2 L's is here. Conrad, hello, Mr. Conrad Siller, familiar face. Zoom user, see you as well. I like this. This is quite festive. This is festive. Brushing a beard is gross only if you're finding bits of food in it. If you're just combing it to get everything aligned, I think it's not as gross. Let's see. Rodney. There he is. Beard brusher. Yeah. When Regier takes 2 minutes, he's going to hit you with every law that applies in your case. So it's not a good situation. But the bunk bed with the Christmas lights, I'm liking this decoration. I really am. Not sure what the other things are on the walls or what you got there. Hold please. Girlfriend waiting in the wings. Honey, look, I told you I'm in court. Yeah, about that. You had to ask. Well, the Christmas decorations are looking great. I don't know what else to say there. Showed us around the room and more. And more. Why did he turn the camera? I don't know. I don't know. That was the wrong move. Oh, that lamp is broken. April, your lamp is broken. Okay, so girlfriend or wife, I'm not sure who. I guess you can also include sister and mom, waiting on the side of the camera in the bare minimum, as regarding coverage, the bare minimum to keep it legal, and so we don't have to suddenly delete the YouTube feed. I don't know the situation. I don't know the situation. I'm just saying it could be all sorts of things. Could be like just waiting for the laundry to finish. April saw it. Yeah, everybody saw it. Except for Rodney, who was combing his beard. I should not have rewound. I'm concerned, given how young... He's in court. He's in court. So I think... but if you sleep in a bunk bed, you should be in court. Oh man. Yeah, there's that. It's legal. It's nothing you wouldn't see at the local swimming pool. But at least what I saw. It could have been a poster on the wall, for all we know. She was holding very still. Maybe it's a college dorm. Possible. Hello there, Mr. Sincere. How we doing? Everything good? We all chill? You chill? We're just vibing? I know there's somebody over there. We're paying it. Lock eyes with us. Lock eyes. What are you eating? Is that pineapple? Just have a big chunk of pineapple. It looks like pineapple. It's either pineapple or a Twinkie. What could that be? No, something else. Looks like a burrito. It looks delicious, and I didn't have breakfast. I'm invested now. Conrad is averting his eyes in case something happens, as is Rodney. Keeps taking bites from it, but it doesn't get any smaller. What could that be? April's upset. Does not approve. She's trying to let him know that she saw. And it's not cool. It's not cool. Corn on the cob, maybe? Lajuan is like, hey, what's happening here? What's happening? He's got it. The hat will have to go, sir. It has to go. And Rodney, your beard is now second place. Olajuwon comes in first. Oh, Lindsay's here. Lindsay's like, hey, what's up? What's happening, guys? What did I miss? Don't ask, Lindsay. Don't ask. Just chill. You're in the center of Hollywood Square. You're the focus of our attention right now. We're trying not to see anything that might happen in the background of Sincere's screen. Olajuwon has the sideways hat. which is really effective at blocking the sun after noon and before, well, at noon it's not as good. You burn one ear when you wear your hat that way. Since you're picking little bits of corn on the cob out of the teeth now. Lindsay Kohler. Her name spelled the way I pronounce the word Kohler. C-O-L-O-R, Kohler. Devontae Johnson, I'm not sure what we're looking at. Is that a smoke alarm or a light bulb fixture? April shows there is, in fact, a picture of a wine bottle on the wall and the broken lamp one more time. The light bulb is hanging down. It should be upright. I'm worried about the wires exposed, April. Lindsay is doing her monologue, prepping for the judge. I think the judge will be impressed. She knows it. It's in her head. I've got it. Okay. I'll just say this and he'll dismiss the ticket. Sincere has taken my spot. Lindsay's ready. April shows the wine bottle again. That looks like a Chardonnay. Am I wrong? Is that a Chardonnay? Lindsay is practicing her spiel. Abby, did we find the soft set yesterday? I don't think we found a soft set. We found, I think, a Pro Se or two, but not like the Pro Se soft set that we were looking for. It's a red wine. It's Pinot. Is it Pinot? I don't know my wines. Cabernet. We did have a soft set yesterday. Looks like a Magnum. Ooh. Gregory's like, I've got a side piece as well. Check this out. Take that, Sincere. April's just trying to make friends here. Smiling at everybody. Hey, I was here first. Lindsay's like, hey, I see you, April. We can be court buddies. Lindsay flips the camera. We get to see what's behind the phone. Looked like a stash of weed. Honestly, that's what it looked like. It looked like some bud. But unfortunate accidental tech mishap. April's ready. Rodney's going to go comb his beard again. Oh, Lindsay has... It's bring your spouse to court day. That's what it is. Everyone, we need 2 people per camera. Just buddy up. I'm a pro at recognizing bud stashes. Gregory's like, stand there, block the light, makes me look better. But no, she leaves. The camera dims. Devontae is starting to get set as well. Lajuan has lost the hat. Looks good. Looks good. Took my recommendation. Gregory's out of here. Ain't nobody got time for that. Rodney's significant other, visible there in the background. So everyone's doing the... Oh, and we got to tour the house with Gregory. This is good. This is good. April, are you by yourself? So much to see in this court. I will pop back on screen when I have room. But right now, Sincere is... we both want to see what Sincere is doing, and we don't want to see. If you know what I mean. What is he eating? He's gone back. It's that same thing again. Oh, yeah. It's got to be pineapple. That's like a chicken bone. April's showing us the lamp one more time. It is broken. We concur, April. It's broken. Pizza breadstick? He's been chewing on the same breadstick forever. Lindsay is just happy to be here. get a big smile from Lindsay, shall we? Oh, they're doing serious faces instead. Conrad's not doing really good at this. It looks more like a grimace. Okay, what is this? What are we eating now? You're biting the corner off of a lotion tube? No, you're cleaning your teeth with a lotion tube. Nice. What ingenuity. What resourcefulness. Yeah, I bet it hurts. You're not supposed to stick that between your teeth. Think sincere as a girl? Could be. Don't know. Lindsay thought it was funny. April is now getting bored. Oh, go with the water. Not Deer Park. And the teeth again. It's what would be sticking in his teeth like that he's chewing on forever? Pineapple? Lindsay doing the whole routine. She was going to do the TikTok dance. Maybe she'll get the nerve to do it. It's in the background so we can't see. Judy, welcome. Hydration is important. April's going to be asleep here in just a little bit. I should be a little quieter. Rodney just went out the front door. Door just shut. Lajuan is vested. I'm not sure if it's in April or Sincere. Sincere just about started laughing with something in his mouth. Rodney's significant other now cleaning up the room. Rodney left a mess. Sincere has an actual dental pick. That's the preferred device. That's how you use it. Yes, you did get something. That's good. Good work. It's a little disgusting to show it afterward, but yeah. That's what you should, not the lotion tube. Use the pick. Devante's here. The judge is here. Waiting for audio. I still don't have audio. Camera 3 has nothing. Camera 8 has nothing. There we go. Why does 3 have no audio? Let's go back to this one. Yeah, we've got audio again. All right, April's ready.
I have a misdemeanor form that indicates that the defendant will be pleading guilty to the charge of B&E of a motor vehicle less than 293-day offense.
B&E is breaking and
Upon
entering.
her successful plea to that charge, count 1 would be dismissed. There's also the understanding that the defendant is agreeing to pay $180 restitution. That's the court's full understanding of the agreement.
Yes, Your Honor.
Yes, Your Honor. And can you state your name for the record?
Jacqueline Murray.
May I have her sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
State your name, please.
Jacqueline Murray.
All right. Ms. Murray, it's this court's understanding that you're going to plead guilty to the charge of breaking and entering a motor vehicle
Yes, Your Honor.
with less than $200, basically. That is a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
I understand.
All right. Still wish to plead guilty?
Yes, I do. Yes, I do.
How
Yes,
do
Your
you-
Honor. I plead guilty.
All
I did
right.
it.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
Okay, you signed an
Lindsay
advice
looks
of
really
rights form,
happy.
is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights. as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No, Your Honor.
Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes.
Of your own free will?
Of course.
Because you believe that you are indeed guilty of this offense?
Yes.
Find my complaint here. On the date of March 10th, 2025, location of 2451 Twin Lakes Drive, Pittsfield Township, Washtenaw County, State of Michigan. What'd you do that, well, to various vehicles, but what'd you do on that date that makes you think that you're guilty?
I entered vehicles and took property.
I think Lindsay thinks this is a dating site.
Say again.
I took property from said vehicles.
All right. You went up to these vehicles. You didn't have any authority to enter these vehicles. Is that correct?
Yes.
And you just either unlocked them somehow or another. You opened the door to the vehicle and you took property located within those vehicles.
Yes, Your Honor.
All right. You did that intentionally?
Yes, I did.
All right. Ma'am, I do have to advise you that if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing that you commit misconduct as defined under the Michigan court rules, you would not be entitled to any sentence evaluation and would not be able to withdraw your plea. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
People are satisfied.
Was the value that was taken under $200?
Well, it's going to be of some value.
Oh, some value. Yeah.
That's why I didn't address it.
Okay.
If you want to go ahead and waste my time, go ahead.
Sorry, Your Honor.
Whoa.
Defense is satisfied.
Court will accept the defendant's plea of guilty to this offense to count two. Count one is
April
dismissed.
blows on us. She just blew on us. She went.
Defendant is referred to probation, pre-sentence investigation, and report. Sentencing will be
January 14th.
January 14th. Are you expected to get out anytime soon?
March.
You don't get out until March.
Oh, well, I'm going to try to put my good time cards in, but yeah, March 14th.
Let's do this. I'm going to do 28. No, I understand that.
Yes, sir, 28.
January 28th, 2026. We'll make that at 12 noon. Okay, I'm putting it a little further out, but you're not going to.
Oh, yeah, no, I'll be
Lindsay and Greg are looking at the same
going
thing.
nowhere.
Are you done with the cases before me yet?
I don't know. I might have one more.
I think they're done.
I hope we're done.
Well, what? What's that mean?
I hope we're done.
I like seeing this one of you. The one that we first got. Oh my God, you were.
Hey.
All right.
You know, sober me is a better me.
Yes.
Sober me is a better
It does.
me. Yes.
You take care.
Thank you, Ron.
Bond will
Thank
continue.
you.
Court calls the case. People versus Kyra Griffin.
I should call this for the people.
Good morning, y'all. Please preside on the court. Brandon Bird on behalf of Shakira Griffin. Ms. Griffin, can you please step to the podium and state your full name for the
Come
record?
on up.
Sorry.
Come up to the podium.
Lindsay's
What's
happy
your
now,
name?
but she's going to have to wait a long time. And I don't think she'll be happy later.
Shakira Griffin? Yes. Okay, thank you.
Yes. We'd like to set this matter for a final settlement conference, Your Honor.
April shows us the broken lamp again. Lindsay checks her fit. Little fit check.
Jury final settlement conference will be set February
Gregory's watching Lindsay.
6, 2026 at 9 a.m. Jury selection February 9th, 2026 at 8:30. Both of those proceedings are in person.
Sounds good. Thank you, Your Honor.
Thank you. Bond will continue. Thank you, ma'am.
All right, Ms. Griffin. Yeah, you go.
Court does call the cases of the people versus Carlos Max. Okay.
April's
Yes,
awake
Your
again.
Honor. Please, this honorable court again. Brandon Bird on behalf of Carlos Mack. Mr. Mack, can you please state your full name for the record?
What is Lindsay doing?
Carlos Mack. Thank you.
This is Public Defender Lauren Perry. I'm the case ID 1404.
1404. All right. What are we doing?
Oh. You go first.
Your Honor, on my case, I'm requesting an adjournment, Mr. License case. We're just gonna see if and when Mr. Mack is released, if he can go to Secretary of State and try to get his license.
Respectfully, Your Honor, I did speak to Sister Prosecutor, and we do have a plea that my client is willing to take today, would be to dismiss the operating while intoxicated and plead to the amended charge of operating while visibly impaired. I need you to sign right. Thank you.
Plea form the court has is indicating that he's going to plead to the charge of operating while visibly impaired, the 93-day offense. Upon a successful plea to that charge, count 1, operating while intoxicated, would be dismissed. That's the court's full understanding of the agreement. Is that correct?
Yes, sir.
Counsel?
Correct, Your Honor. Sorry,
Thank
sorry,
you.
Your Honor.
No, it's okay. You're busy doing something else and ignoring me.
Oh, no,
May I
no.
have him sworn, please?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Carlos Mack. Before I go on to that, Miss Perroni, I will adjourn the 1404 case. I'll adjourn that. Will the 7th work? Well, he's got to get out.
Yeah, I don't know. Obviously, how long I'll be in custody, so.
Why don't I just adjourn this out to the 21st of mine?
Yes.
January 21st, 2026 at 9. If he's not out at that point, we'll at least see him and figure out where we go on that one.
Thank you.
All right, we'll continue on that case. All right, sir, it is this court's understanding that you're going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, a $300 fine plus court costs. The court could order community service, any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services. You understand all of that?
Yes, sir. Yes, Your Honor.
And understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
All right, you signed an advice of rights form, is that correct?
That's correct, Your Honor.
Any question regarding any of those rights?
No, sir, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy there. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yep. I would say.
You understand you're giving up those rights?
That's correct, Your Honor.
All right. You understand that you're giving up your right to appeal of right?
That's correct, Your Honor.
Are you on probation or parole?
No, sir, Your Honor.
Has anybody promised you anything other than
No,
what's
Your
been stated here today to get you to plea?
No, sir, Your Honor.
Anybody threaten you or coerce you?
No, sir, Your Honor.
You're doing this voluntarily?
Yes, sir, Your Honor.
Of your own free will?
That is correct, Your Honor.
And because you believe that you are indeed guilty of this offense?
That is correct, Your Honor.
They had these out like they did on the other ones. Hang on, I'll fix that. They put that there. Sir, on the date of January 28, 2023, at the location of Ellsworth Road near Ridgewood Drive, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
That is correct, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
That is correct, Your Honor.
What do you have and how much?
I'm not quite sure, Your Honor.
Not quite sure how much, but you did.
Yeah, what I was doing.
Did the police stop you or was there an accident?
I was stopped, Your Honor.
Why'd they stop you?
Let's run into a tree.
Headlights.
Go.
I was impaired.
Well, okay.
We know that.
Do you know why they pulled you over?
No, sir. I was impaired. That's the reason.
Okay, and that was exhibited by some erratic driving and your headlights weren't on, or what What would they know from the outside to pull you over that you're aware?
Driving on the line.
Pardon?
Driving on the line.
Driving on the line.
I would have to
May I
ask the officer.
Yes.
Sir, at the time that you were operating that vehicle, was it 23:37 hours as in dark outside?
That is correct, John.
Was your vehicle, did you use your headlights on your vehicle?
That was the fog lights. No, ma'am.
You had.
You had running lights on but no headlights?
Can you just answer her question?
No, I do not have.
Did you have headlights on?
No, sir. No, Your Honor.
And so you didn't have the proper equipment.
That is correct.
To operate a vehicle in the dark.
So it was
That
a
is
legal
correct.
stop.
Right? And that's why they pulled you over. Is
That
that
is
correct? Thank you. You're not disputing the right of the police to pull you over.
No, sir. No, Your Honor.
And were you ultimately arrested?
That is correct.
And were you taken to the hospital or were you taken to the police station?
I went to the hospital and then to the police station.
Or did they do a blood draw?
Yes, they did.
And what were the results of the blood draw?
0.17.
0.177?
I would believe.
Are you disputing those results?
No, Your Honor.
All right. And don't have a reason to dispute those results?
No, Your Honor.
On taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
That is correct, Your Honor.
Sir, I would have to let you know that if between the time of sentencing and between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, that you would not be entitled to rely upon any sentence evaluation, as the court would no longer be bound by that, and you would not be entitled to withdraw your plea. You understand that, sir?
That is correct.
Counsel, are you aware of any other promises, threats, or other defendant's plea to count 2? Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel.
All right.
Sentencing in this matter will be
April.
January 14th, 2026,
April's
9 a.m.
Permission to address bond, Your Honor.
Briefly.
Respectfully, Your Honor, my client has been in since, I believe, 11/19, roughly around a month now. If we do wait to the January 14th date, he would have almost spent 60 days in the jail, which would be over half of the maximum penalty for this charge. He does understand the severity of his actions. He just displayed to the court that he's not trying to waste the court's time. Took accountability for his actions, understands the ramifications of what could happen if he doesn't follow the court's orders, and respectfully, we're asking to reduce his bond to a personal bond, Your Honor.
Your Honor, the people's position is that we'd like to have Ms. Pilar meet with him before that, and we trust her judgment and ask that the court continue to bond him.
And that's what I'm going to do, which is customary for this court. I'm not going to do anything regarding his release till he's met with the probation. In particular, given the circumstances, he didn't make it very far from arraignment before he violated the condition of his bond. Ooh. So motion for bond reduction at this time is denied.
Thank you for hearing me out, Your
Thank you for hearing me out, Your Honor.
Court does call the case of the people versus Marcus Stewart. That it for you, Mr. Bird? Is that it for him?
Nope.
That's it?
Yes. Marissa's here. Marissa Voles. Hello, attorney.
He tried to hide behind Miss Pate, and it didn't work. I saw you. Marcus Stewart.
On behalf of Pittsfield Township.
Good morning, Mr.
Bills P8643 on behalf of Mr. Stewart.
Mr. Stewart, can you state your name, please, sir?
Marcus Stewart.
Okay, I have two cases here. What are we doing?
In the township case, Your Honor, he does have a valid license, so he's going to admit double parking. He'll probably need to waive the reading and stand mute.
Has he been arraigned on that at all?
I don't think he.
So, counsel, on that case, you're waiving reading of the complaint on the Pittsfield Township case ending in 0894.
Correct, Your Honor.
And your client is standing mute. Defendant having waived formal reading standing mute. Court will enter a not guilty plea on his behalf. And then the people are adding a count 2 of double parking.
Correct, Your Honor.
And upon his plea to that, then count one would be dismissed. Is that your understanding, counsel?
Yes.
All right. And so, Mr. Stewart, do you admit responsibility to the fact that on May 20th, 2015, there was like three. Anyway, May 20th, 2015, Packard Road near Gulfside Road, Pittsfield Township, Washington County, State of Michigan, that you double parked the motor vehicle?
Yes.
It's an 11-year-old case. We'll accept that admission to count two. Count one is dismissed. Fines and costs of $180. When do you think you can get that paid, sir?
I can have that paid within the next 2 weeks.
All right. Get it paid before the end of the year. Can you get it paid before the end of the year?
It's looking good.
Yes, sir. Yes, Your Honor.
So just pay it by December 30th, 2025. All right. Then on this other case, what are we doing?
On that one, we're just going to request an adjournment for discovery.
And if I may, Your Honor.
Yes.
Assistant Public Defender Lauren Perry on behalf, well, not on behalf of Mr. Stewart. I just want to inform counsel a substitution is needed on
oh shit. Okay.
0547. We're still the attorney of record in the ROA. So Ms. Boyles, you can email me directly. I can we can get it done, or you can contact the public defender's office.
Okay, I'm just looking. I thought we already filed that one. It may not have been.
You know what? You're right. I do. I actually have it.
I only have an appearance. I don't have the stuff.
I have substitution of counsel that I signed actually back in November.
JIS just is not
Marissa.
Right. JIS is not updated. All right. So no reason to yell at the attorney, Perry. She did everything she was supposed to do. I knew that. I was going to defend her.
Mr. Stewart.
What'd you say?
I just don't want any confusion for Mr. Stewart.
He's not confused.
Well, good.
Counsel's not confused. You were the only one that was confused.
I was.
I had it. I got it. All right. So anyway, counsel, you're looking for an adjournment?
Yes, please.
Will January 7th work for you?
Yes.
All right. I'll adjourn the matter to January 7th, 2026. 9 a.m. or as your invite indicate. Bond will continue. All right. Thank you, folks.
Your Honor.
Thank you.
Court does call the case. People versus Marcus Jackson.
Actually felt this.
David I. Goldstein appearing on behalf of the defendant.
There goes Marcus.
Marcus Jackson.
Thank you. I will also sign the substitution on that.
Thank you, Your Honor.
We need Lindsay
Your Honor,
to come
Ms.
back on
Feltus
screen.
and I have discussed this matter. Mr. Jackson has several felonies pending in circuit court. In fact, he has a pretrial this afternoon. My anticipation is this case is going to be wrapped into whatever resolution in those cases. So if we can have till the 21st of January, we should be able to get things taken care of.
Yeah, this is the minor
Turn the
case.
matter without objection, January 21st, 2026, 9 a.m. Bond continue.
Thank you.
Thank you. Thank you, Mr. Jackson. Court calls the case of the people versus Kristen Dameron.
Ashley Feltus for the people. Good morning. Your Honor, we have come to a resolution. Mr. Dameron has given me permission to admit to no proof of insurance on his behalf.
And that is the offer to add count 2 of no proof of insurance, 257328, I believe, Your Honor.
328.
Okay, that's correct.
And then count one would be dismissed.
Yes, Your Honor.
I was mistaken.
Ms. Perry, on behalf of your client, do you have
Elijah one was combing the beard, not Rodney.
On November 1st, 2025, at location of US 23 in Pittsfield Township.
Serious sleeping.
That upon request of a law officer, they failed to provide proof of insurance.
I do.
All right, court will accept that admission. Count one is dismissed. Fines and cost of $155. Do you know when they can get that paid?
He's asking for 2 weeks.
Tell them they pay it by December 30th.
I think April's
2025.
folding laundry.
Why is he lawyering? Court calls case People versus Michelle Campbell.
I just felt this for the people, it matters.
Didn't he say goodbye? He's just loitering. It's like hovering over Cook.
It's working very hard.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Campbell. Ms. Campbell, state your name for the record, please.
Michelle Campbell.
Thank you, ma'am.
Morning, Mr. Jones.
Good morning.
Your Honor, an offer was made on this case. Ms. Campbell and I did have an opportunity to discuss it. We're just hoping, I'm hoping to check in with the people to see if there's any additional surveillance footage. I have not communicated that request to them yet. So if that's the surprise, that is why. So I will get in touch with Ms. Cook and Mr. Cook and Ms. Feltis about that request.
And I will do community service.
Already taking hits. Okay. Actually, that was probably a promotion. Anyway.
So that's my request there. I'm just asking for an adjournment. I do have another a treatment request as well.
Lindsay's working on a craft.
Ms. Campbell's up before Your Honor tomorrow on a PCC. I believe it's a resisting and obstructing charge. I think there's an agreement there for Ms. Campbell to be released to treatment. I'm asking for release on this case as well. If the court and the people are amenable to that, I'll submit an order.
Any objection to that from the people?
The single, we would talk about it ahead of time, so I didn't know it was coming, but the concern I have is it looks like we might have failures to appear along the way here. So I'll leave it in the court's discretion, but that would be the one sort of asterisk I would point out to the court.
All right. But I think her order includes release on a GPS if she's going to go. So, hey.
I feel a lot better.
Then that's the way the order would read, because I think the other order reads that way.
Yeah.
So if you submit an order for release to treatment on these cases, then.
Okay. All right.
All right. I'll adjourn it to the 7th, 2026, 9 a.m.
Oh,
Thank
April,
you,
no.
Your Honor.
Take care.
Honey. Yeah.
Court calls the case of the people versus, is it Richland? Okay.
I just felt this for the people.
It's probably not. Okay.
Assistant Public Defender Natalie Pate, on behalf of my client, who stands to my right. Please state your name for the record, sir.
Richland Decay.
It is Decay.
Yes.
Okay. Hey, I got it.
First try.
And Your Honor, this is we're going to be moving to dismiss.
What
Certainly
is
no
Lindsay
objection.
making? Lindsay's making
Case is
something.
dismissed. Thank you.
Thank you, Your Honor. Thank you.
Now her back hurts from bending over and pulling on strings. April popped a candy in her mouth and woke her up a little bit, but now the
people
sugar
versus
crash.
Ishmael Davis.
Felt this for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Davis. Mr. Davis, state your name for the record.
Ishmael Alexander Davis.
Thank you, sir.
Your Honor, we have been here a couple times. We're waiting for
What's
Mr.
Lindsay
Davis
got?
to be released to treatment. I'm asking for an adjournment again for that purpose. Hopefully, once he completes treatment, we can come to
a resolution.
the resolution. We've been still trying to work on a hold out of Wayne County that no one can find. Mr. Davis and I worked yesterday for like an hour trying to calling all these police departments and courts to see where this hold is out of, and we can't figure it out. So we're still working on that. That's what's keeping him up, holding him up.
Are they not releasing him to treatment here because of that hold?
Right. We thought it was a hold out of Third Circuit. However, we arranged a video hearing. He saw Judge Ramsey in the Third Circuit, but there's no warrant. There's no warrant on that case, so we just can't find where this warrant is coming from. So I'm still working on it.
You can't.
So it's the hold. If the court wants to know, the hold in X jail says Wayne Police Department. I've called Wayne, the City of Wayne Police Department. I've called the court, and they have nothing on him. So we're chasing it down.
All right, here's what I'm going to do. I'm going to adjourn it to January 21st, 2026. That's a bit of time out there. All right. And
April's falling asleep.
We can't.
About to drop the phone.
Yeah.
Okay. And then, all right, in this case, his bond will continue. council approach on a separate matter.
Council approaches. Sincere is taking a nap and has turned off the camera. April wants to be taking a nap but has kept the camera on. Lindsay has stepped away from the camera, blurred the background, and is working on some sort of craft. I'm not sure exactly what, but involves several lengths of string, all the same size. Olajuwon, when he puts his hand on the top of the camera like that, the plant that is visible from the top of the screen looks like he has big, majorly hairy knuckles. April now showing us the broken lamp. Gregory is fighting with the sun, as is right in his eyes. He's already shifted positions before. This is our updates. This is what we have. Lindsay's working on macrame. What is Lindsay? She's charged with OUI. Okay, operating while intoxicated. That would explain why she's so happy. Might be a first offense. April is making me dizzy now. Do they realize that court is watching, that we're watching?
Court does call the case People versus Grant Decia.
I'm not sure if they
Good morning,
realize the full
Assistant Public
scope.
Defender Lauren Perny on behalf of Mr. Ducia. Your Honor, I don't believe Mr. Ducia is present. He, if the court can remember, the last hearing was in the hospital. The hospital sent information. He informed me he was readmitted into the hospital. I communicated with him yesterday. So that's my most recent update that I have for him.
So he's back in. He was out, and now he's back in.
Right.
Continue.
He is up for PCC before you tomorrow as well. Both of these cases have kind of been tracking each other.
Along. All right.
Yeah. Did the hospital send anything to the court?
I think before.
They definitely did before. All that.
I don't know this time.
I don't have
April's
anything,
gone.
or
Oh,
at least
there we go.
nothing has come directly to my attention on that. Here's what I'm going to do, though. I'm going to adjourn this out to January 21st, 2026, 9 a.m. And just indicate to council to get us information.
Sure.
On that. All right.
January 6th, Your Honor?
No, I went to the 21st.
Oh, I'm sorry. Thank you.
Because he's going in and out, and then there's going to be another case that's going to be up tomorrow that will.
She's about to drop the phone. April's going to drop the phone.
Right, thank you. Court calls the case People versus Leo Stringer.
Lindsay's almost finished with her art
And
project.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Stringa, who stands to my right. Please state your name for record, sir.
Leo Stringer. All right. I have 2 plea forms, both indicating that he's going to plead no contest to the charges of retail fraud in the 3rd degree, the 93-day offense. Upon his successful plea in each of those cases to that, and on the form for 0612, he's pleading to count 2. It says count 1, but I think he's pleading to count 2 on that case.
Correct, Your Honor.
Just so that we're clear on that. Well, no.
No, 0612, he's pleading as charged to retail fraud in the 3rd degree. And then in 1106 is an added count to a retail fraud in the 3rd degree.
Correct.
Hold it. So I see. That is count 1 on that form.
Oh, we have a pup.
That's also part of the dismissal of retail fraud second in the other case.
Yes,
even
correct.
though in the other case he's pleading and it's going to be dismissed on that court. Got it. Okay. I now follow.
Rodney's
All
also
right.
Rodney's
And
outside.
then
By the way, he left.
also that he's going to plead
there he is.
no contest in the case 612, which is actually this case.
This is
and plead no contest to an add count 2 in that case. All right. So I'm not sure why I have all this on the form. I get it.
They're trying to show the dog off.
Yes, Your Honor. Yes, you'll be pleading as charged the retail fraud 3rd in the case ending in 612, and in the case ending in 1106, he's pleading to the out. Yes.
Yeah, have him sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Leo Stringer. All right. Sir, it is this court's understanding that you are going to be pleading no contest to 2 charges of retail fraud in the 3rd degree.
Correct, Your Honor.
All right. Those are misdemeanors. punishable by up to 93 days jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum amount of the fine. You understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
2 things about a no contest plea. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest these charges. You understand that?
Yes.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
You still wish to plead no contest?
Yes, Your Honor.
To the charge of retail fraud in the 3rd degree as contained in the case ending in 0612. How do you plead?
No contest.
To that same charge as contained in the case ending in 1106. How do you plead?
No contest as well, Your Honor.
You understand that by pleading no contest, you will not have a trial of any kind.
Right. Yes, I'll give up those rights.
All right. So you understand that you're not
Is that a slushy maker?
You understand you signed an advice
Does
of
a
rights
larger one
form,
have a,
is that correct?
slushy maker?
Yes.
Or a
Any
daiquiri
questions
mixer or
regarding
something?
any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. You understand that those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights that
we got
contained on
dropped.
that form.
Yes.
You understand you're giving up your right to appeal of right.
Appeal them, yes.
April's dropping us.
You understand you're giving up your right to appeal of right.
Oh, yes. Yeah.
Are you on probation or parole?
No, not anymore. You discharged me last week.
And sentenced you to jail.
Yes, sir.
Yes.
So he's not.
He's not on probation.
Yes.
Anymore. Has anybody promised you anything other than what's been stated here today on the record? To get you
Zoom user?
No, Your Honor.
Has anybody threatened you or forced you?
No.
You're doing this voluntarily?
Yeah, on my own accord.
He's
Of
listening
your
to
own free
all
will.
of this.
Yes.
He knows what comes
The court
next.
has been provided 2 police reports. The first police report dealing with case 0612, Pittsfield Township Department of Public Safety report for their case number 256458. And in the other case, 1106, Pittsfield Township Department of Public Safety report for their case number 258906. Any objection to the court having reviewed those reports?
No, Your Honor.
No.
Based upon a review of those reports, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of each of these counts of retail fraud in the 3rd degree. Mr. Stringer, I have to advise you that if you commit misconduct as defined in the Michigan court rules between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation and or recommendation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
No, Your Honor.
No.
Hang on one second. And has the court complied with the court rule?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea in case 0612 to count to the single count in that case of retail fraud in the 3rd degree. In the other matter, the court will accept the defendant's plea to count 2.
Rodney's stroking his beard now.
Count 1 is dismissed.
His emotional support person at his side. Give him a little back rub encouragement. You'll be
Defendant
okay.
is referred to probation for pre-sentence investigation and
Not sure what Lindsay's
recommendation. Sentencing in this matter will be January 14, 2025, 26, 9 a.m. Bond will continue.
Thank you.
April is out. She's asleep.
Thank you, Your Honor.
Thank you, Your Honor.
This is like REM 3.
Court does call the case People versus April Fleming.
April, wake up. She is
Good morning,
here.
Assistant Public Defender Warren. Let me just state your name for the record.
Sorry.
Hi.
State your name.
April Joy Fleming.
Joy.
Yeah,
You knew it was Joy.
asking for hopefully one last adjournment. We've been adjourning for medical records. We did get some medical records are waiting for records from Trinity Health. Hopefully I can get that mitigation over to the people in a couple of
Ms. Fleming,
Yes.
were you huffing on Zoom?
I'm sorry?
Were you huffing?
No, I was not.
Are you sure?
Yes.
So if it was reported to me by two people that you were, they wouldn't be telling the truth?
I don't understand what you mean. Was I huffing when?
Today.
Do we have to
Today?
rewind?
No.
Where do you live?
I live at Chittister Place of.
How long will it take you to get here?
I don't have a ride or anything. I don't know.
Judge can arrange for one.
To get there today?
Yeah, today. We saw you doing something you probably shouldn't have been doing.
What do you mean, sir?
Were you huffing?
Was I huffing just now? Like on camera? No.
Okay, today off camera, on camera, you've been huffing?
No.
Not at all?
No.
So if you came down here and I sent you over for a test, everything's going to come back negative?
Yes.
It will?
Yeah.
Okay, you're going to need to find a ride. I'm going to need you down here.
Okay, sir. I don't know how I could get there.
Miss Fleming, I'm gonna give you a call, okay?
Okay.
Thank you.
Thank you.
Okay.
Council approach first.
Did we miss something? Did that happen and we miss it? Who's going to go back and find it? Got to be quick because this will be gone. We don't have this one. We don't have all morning. I mean, she might have been on. This could have been on the previous block. Okay, she was here all morning. The lamps were moving. Huffing refers to inhaling the fumes of usually glue or paint or something like that. It's done to induce a high. It's extremely bad for you. It gives you also a massive headache. Aerosols, glue, gas, paint. She's showing around the room evidence, I think. It's what's referred to as a cheap high, generally because the materials that are used are readily available. Compressed air. A lot of things have like compressed air now has like a bittering agent to make it less enticing to use. It's basically just starving your brain of oxygen to induce a high. It's extremely dangerous. You can pass out, first of all. And anytime you're starving your brain from oxygen, you can imagine what your brain cells are doing without any air. I know when I was younger, there was a guy who was huffing glue, which involved putting glue in a bag and breathing the fumes while he was driving on the freeway. Passed out, lost control of his car, crashed into somebody else, went through the fence and drove into a pond. And a passerby, not knowing obviously what caused it, saw the accident, jumped in, risked his own life, got the guy out of the car and saved his life. Having no regard for his own life to save the guy who didn't care about anyone else's. Not a good thing. Well, tell you what, let me go back on the replay. What do we have? Are we on replay? Let's see. We've got audio on 2, video on 2 as well. Okay, so I can use this one. Let me go back.
Got it. Court does call the case People versus Jared Taylor.
Ashley Feltus for the people.
An Assistant Public Defender, Natalie Tate, looking on behalf of Mr. Taylor, who states to my right. Please state your record, sir.
Yes, my name is Jared Taylor. Thank you. All right. Jared Taylor? Yeah, I got you. Oh, okay. Yeah. All right, I have 2 plea forms in front of me, both indicating that he's going to be pleading to retail fraud in the 3rd degree. In the case ending in 0910, that's an added count 2, with count 1 being dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor. And that is our full understanding as well, Your Honor. Correct.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, I do. State your name, please.
Jared Taylor. Jared Lee Taylor. All right. Sir, it is this court's understanding that you are going to be pleading guilty or pleading no contest to 2 charges of retail fraud in the 3rd degree. Is that correct? That's correct, sir. All right. Those are misdemeanors punishable by up to 93 days in jail, up to a $500 fine plus court costs. You understand that? I do. You understand that the fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that? Yes, sir. All right. Do you understand what a no contest plea is? Yes, I do. 2 things about it I have to make sure that you understand. The first thing is I have to make sure that you understand.
Josh, can you text me how far back?
To make sure that you understand that it means that you're not further desirous or wanting to contest these charges. You understand that? I do, sir. Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that? I do, sir. All right. Basis for the no contest, please.
Potential liability, Your Honor.
All right. So, sir, to the charge of retail fraud 3rd degree as contained in the case ending in 0910, how do you plead? Guilty. Oh, I'm sorry. No contest. To that same charge as contained in the case ending in 1291, how do you plead? No contest. Now, you understand that by pleading no contest, you'll not have a trial of any kind? I do. All right. You signed an advice of rights form, is that correct? I did. Any question regarding any of those rights? Not at this time. All right. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form? Yes, I do, sir. You understand you're giving up your right to appeal of right? I do, sir. All right. Are you on probation or parole? No. Has anybody promised you anything other than what's been stated here today on the record to get you complete? No, sir. Anybody threaten you or coerce you? No, sir. You're doing this voluntarily? Yes, I am. Of your own free will? Yes, along with my attorney's advice. Pardon? Yes, sir. I was just saying, along with my attorney's advice. Okay, your attorney's advice, but yes, the decision to plead is your decision. It's my own, yes. Correct? Yes, sir. Yes, sir. Yes. All right.
No, you're good. No, you just said advice. That's fine.
Court has been provided 2 police reports in the case ending in 0910, Pittsfield Township Police Report for their case number 2413677. And in the other matter, it's Pittsfield Township Police Report for their case number ending in 259595. Any objection to the court having reviewed those reports?
No, Your Honor.
No, Your Honor. Sorry.
Based upon a review of those reports, the court does find that there's a sufficient factual basis in which the court could could determine the defendant's guilt
Okay, we're
of
gonna
these
go back and
offenses.
watch and see what happens.
Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, first of all, you would not be entitled to withdraw your pleas, and any sentence evaluation or recommendation, the court would no longer be bound by. You understand that, sir?
I understand. Thank you.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Josh, is
And
it
have I
1 hour
complied with the
52
court rules?
back?
Yes, Your Honor.
She's
Court will accept the defendant's plea of no contest to count 2 in case ending in 910. Count 1 is dismissed. In the other matter, I will accept the defendant's plea of no contest to the single count. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in these matters will be January 14th or January 28th, 2025, 26. All right.
Thank you, sir.
Bond will continue. Thank you.
Thank you very much, Your Honor.
Court does call the case of the people versus Deanna Conrad.
Mr. Phelps with people.
okay. Are we too far back or too far forward? I've
Good
seen
morning, Assistant
screenshots
Public
of the
Defender Lauren
can
Perny
in
on
her
behalf of
hand.
Ms. Conrad. Ms. Conrad, state your name for the record, please.
Deanna Conrad.
All right. Court has a plea for, is that what we're doing?
That is correct, yes.
The defendant is going to be pleading to operating while intoxicated, to the charge of operating while intoxicated, that being an added count to the 93-day offense. Upon our successful plea to that charge, count 1, the operating with a high BAC would be dismissed. That's the court's full understanding of the.
Yes, Your Honor.
That is our understanding as well, Your Honor.
May I have her sworn?
Raise your right hand. Do you
Okay, so
solemnly
she-
swear to affirm the testimony you're about to give will be the truth?
She
the whole
shows us
truth,
the
and nothing
lamp
but the
when
truth, so help you
she's
God.
I do.
State your name, please.
Deanna.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail, a $500 fine plus court cost. Court could order community service and any rehabilitative programs the court deems necessary. The court could also order your being immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
I do.
All right. Still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
I understand.
All right. You signed an advice of rights form, is that correct?
I did.
Any question regarding any of those rights?
No.
You'll see a copy of one on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as other rights on there.
I do.
You understand you're giving up your right to appeal of rep.
I do.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
I am.
of your own free will
Sir.
and because you believe that you are indeed guilty?
I am. Yes, sir.
All right.
There's only one
On
thing
the date
I
of July 2nd,
approve of huffing,
2018,
and that's this can right here
location of I-94 near
oxygen.
Platte Road in Pittsfield Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, you consumed intoxicating liquor.
I did.
Do you recall what you had and how much?
Being a brandy drinker, I'm sure it was brandy.
All right.
I don't remember how much.
Were you stopped by the police?
No, I was not.
All right. Was there an accident?
I was.
What happened?
I veered off of the I-94 and off of the road, and I hit a tree. What is it? The embankment. I hit a tree.
Did the police and ambulance arrive?
Yes, sir, they did.
And were you taken to the hospital?
Yes.
All right. And was there a blood draw, ma'am?
Yes, yes.
And if I told you that the results of that blood draw were 0.255, would you have any reason to dispute those results?
I would not.
Counsel stipulate to those as a result.
Yes.
Yes,
All right.
255 is high.
And you don't have any reason to dispute those test results?
I don't.
Pardon?
I don't.
All right. Ma'am, if I accept your plea, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rule, the court you would not be allowed to withdraw your plea, and the court would no longer be bound by any sentence recommendation or evaluation. Do you understand that?
I do.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court law?
Court satisfied.
Satisfied, Judge.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation. Well, defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
January 14th.
January 14th, 2025, 26, 9 a.m.
And Your Honor, I did have a request regarding bond and potentially the sentencing date. The court probably knew that was coming. So we are requesting a personal bond. Miss Conrad, I've been messing up everyone's pronouns today. I'm sorry. Miss Conrad has been in custody for 14 days as of today. As the court knows, Miss Conrad has taken responsibility from this incident that was almost 7.5 years ago. Her prior is from 15 years ago. I had a chance to speak with Miss Conrad this week about, what happened in her life that kind of made these incidents occur. She stated both actually arose the same nights that she lost her parents. Her father passed 15 years ago, and her mother passed 7.5 years ago, the day that this incident occurred. Since this incident, she has not had any other interaction with the criminal justice system. Again, she's taken responsibility for her actions on that day. She did plead to the lower charge. She's very eager to get out of custody and get back to work. She's currently on a leave of absence, and that leave of absence expires on the 19th. She's been at her job for about 3 years. She works a good job, and is concerned about that job, losing her income, losing her health insurance, things like that. I don't believe Ms. Conrad's a flight risk. She did come to court on the 3rd.
I'm not so much worried about her being a flight risk. I'm worried about her drinking.
I can guarantee you it won't happen soon.
So you already did that once, and that did work, right?
I will say too, Ms. Conrad's been in custody. She's been out of work. I did ask if there's any bond she could post. She believes she could post about $250 to demonstrate to the court that she will comply with any conditions. I will also say she did complete an assessment that was used in negotiations with Von Schwartz. That assessment was provided to Ms. Plura, I believe, when it was done a few weeks ago. I'd asked the court if the court is intending to keep her in custody, set sentencing for the 22nd. I know January 14th is quite a ways away. The holidays are coming up. So that would be my secondary request is do the sentencing as quickly as possible. I know that's hard for everyone involved, but the assessment has been done.
Okay, I think Josh has given us the timestamp. Thank you, Josh, for taking this up. We're leading up to the point where April.
Concern of the people is the concern of the court. I think we had 3 confirmed drinking events while the defendant was on a scram tether. I know that was a couple months ago, and the people have recognized the age of this offense and her lack of contact with the criminal justice system since it, and with the plea offer that was made and accepted. However, I would feel much more comfortable letting Ms. Pilara have the interaction with the defendant, making the decision and advising the court about whether or not she thinks she can be safe in the community. We do understand the holidays are coming up. I think this court is well aware that can be a very triggering time for people who struggle with alcohol. If this was a case that had happened in 2018 and we had no bond violations and nothing else along the way, I would most likely have a very different position. But I'm concerned that this is an an ongoing problem for the defendant, and I'm worried about the safety of the community.
Anything else?
Nothing else from me, Ms. Conrad. Did you want to add anything to what I said?
All I can do is plead with you. If I lose my job, I will lose my health insurance and possibly my home. At my age, it'll be hard for me to get health insurance pre-existing because, Your Honor, I will not consume any alcohol. I will not.
The judge is on the left listening, not the one on the right. The right's a replay.
I don't know what else to say. I can more than promise, I'll guarantee it. I will not consume any alcohol if you allow me to go and salvage.
There's the
my
aerosol
job
in her hand right there on the bottom right.
Here's what I'm gonna do. And I'll be honest with you, Graham, I wish I could just sort of take what you're telling me on faith. It's a bit hard to do given where we've been in this case, right? I mean, here's cold-hearted reality that almost 7 years ago or whenever this occurred, lived through that.
I'm sorry.
Lived through that.
Yes.
I mean, it's in a sense a miracle that we're even talking to you today.
That could never happen again, sir.
Here's the problem. You can't, and I understand you're giving me the guarantee. I understand all of that. And I would love to just take it on face value that that's what's going to happen. But you get here 7.5 years later and you can't, and you get put on a scram and you mess that up. And I think the prosecutor's correct. What really worries me about sometimes releasing people at this time of year, not only is this time of year triggering, but there's a lot of things around that could cause you just to slip up again. All right. And you can, in your heart, believe that won't happen. The problem is, I don't know that you can really say that with any surety. I don't doubt that you'll give it your best efforts because I don't think you like where you are right now. You've got a problem, and I say a problem, and that is that it's something you have to deal with.
It's addiction.
We'll set her sentencing for the 14th, January 2026, 9 a.m. If Miss Polera and Ann, if we can fashion some type of release since her assessment is already done, I'd like a recommendation from Miss Polera on her, and then I'll make a decision. But at this point, her bond would continue as is. But I'm going to take a look at the documentation from the assessment, have my probation officer look at it, and then make a determination if we can release her in some fashion.
I'll get in touch with Ms. Pilar today, Your Honor.
All right.
No, the omnipresent Ms. Pilar.
I know, it's scary. All right. Okay, so that's the way we'll do it. Thank you. Court does call the case of People versus Trayvon G.
People.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. G, who is here on Zoom. Sir, can you please unmute and state your name for the court?
Yes, Trayvon G.
He's driving.
All right, what are we doing?
Thank you, Your Honor. Your Honor should be in receipt of a plea form as well as a plea report.
All right, the plea form indicates that the defendant will be pleading no contest to the charge of embezzlement by an agent or trustee less than 293-day offense. which is as charged.
Embezzlement less than 200.
That's the court's full understanding. Well, there's also that the prosecutor will recommend prosecutors deferred sentencing. That's the court's full understanding.
Yes, Your Honor.
That is our complete understanding, Your Honor, as charged under
Mr.
the.
G, please raise your right hand. Do you solemnly swear?
When I got my truckers, they're going to come take the cars off the roads and bring them down to Enterprise for us, so all of our teams can just hit our pump.
Hello?
Hello?
Yeah.
What?
Can you turn your
Well,
I can't barely
talk.
No, I can't barely hear you. It's going in and out the signal.
That's not the problem.
Yeah, but what is
It's
that
your
in
work
the background?
radio.
Oh, I'm at work. I turned that down. It was my work radio for my job.
Gum,
All right.
hat,
Yes,
work
that's
radio,
fine.
and your
Sir,
driving.
it's this court's understanding that you are going to be pleading no contest to the charge of embezzlement by an agent or trustee.
Yes, Your Honor.
That's a misdemeanor punishable by up to 93 days in jail, a $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken.
Nike
If that's
made the
greater than
appearance.
greater than $500, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor. I talked with my public offender. She explained it to me.
Okay.
Public
Two things you have to
defender.
know about it. It first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, I did.
Any questions regarding any of those rights?
No, Your Honor.
You understand that you're giving up those rights, particularly the rights that are contained in paragraph 5, your trial rights.
Currently Q. Thank
Yes,
you
Your
very
Honor.
much.
You understand you're giving up your right to appeal of right.
We have a baby
Yes,
in
Your
court,
Honor.
too.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And because and of your own free will. The court has been handed and has reviewed Pittsfield Township Department of Public Safety report for their case number 2413164. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No.
And have I complied with the court rule?
People are satisfied.
Yes.
Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for pre-sentence investigation and report and determination of prosecutors deferred. Sentencing in this matter will be
January 28th at noon.
January 28, 2026, 12 noon. All right?
Yes, sir.
Thank you. And hang on the line. We're going to put you into a breakout room with our probation intake so we can get the process started. Okay, sir?
Okay. Yes, sir.
Thank you.
Thanks,
You're
Mr.
welcome.
G.
All right. You too.
Courthouse
Mr.
case, People versus Joseph Griffin.
Conrad Solar on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Griffin. Griffin, state your name for the record, please.
Joseph Pershing Griffin, Your Honor.
Your Honor, Mr. Griffin is another individual that we're waiting on a release to treatment on. He has a couple cases up in circuit court that are being worked out, and a couple holds in Canton that we're working on as well. So I just asked for an adjournment.
Turn the matter out when I go to the 21st, just January 21st, 2026, 9 a.m. we need to see him before that.
Thank you. I do think there's a release on this, on all of his
I think there's a
files.
release on that case.
Yeah.
All right.
Thank you.
Thank you, sir. Court, good. Let's call the case. People versus Keontae Wright.
Felons for the people.
Sincere is sleeping. Lindsay is
Keontae
now.
Wright.
Assistant Public Defender Natalie Pate with behalf of Miss Wright, who is approaching.
Kayla has her child in tow.
Your name?
Keontae Wright. Thank you, Your Honor. I'm respectfully requesting an adjournment. I have been able to discuss this case with Miss Wright, and I was able to provide her with a discovery packet today. We're asking for some more time to review some of the media discovery together.
January 7th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case versus Trevor Howard.
Ashley Feltus for the people.
Good afternoon, Assistant Public Defender Lawrence Kearney on behalf of Mr. Howard. Mr. Howard, state your name for the record.
Trevor Scott Howard.
I apologize, Your Honor. I thought this case was set for January 7th when I checked the ROA yesterday. I did not speak with Mr. Howard. It came up on my case management system. He wasn't on the initial docket sent out by the court, so I checked the ROA. So I apologize to Mr. Howard.
It looks like Mr. Howard has a felony that's up tomorrow as well, so maybe that has something to do with it.
April's been ordered to the courthouse. She'll be there
PCC
today.
tomorrow, or is
Yes,
it circuit court?
PCC.
Wish Lindsay would show us what she's working
Well,
on.
what I can do is this, Ms. Fairney. He's being held on that other.
On the felony case.
It does look like he's being held on that one. The notes in it from Extenda from October of this year indicate he failed to appear for a probable cause conference.
Okay, let me mute this for a second. Rodney's significant other just took a selfie behind his back of her watching court with him on it.
He probably, his bond has been denied in that case because it has in this case also.
Okay.
Because, I'm sure because of the tether being cut.
Well, Your Honor, I just wanted to make sure if there's anything that I need to say today that could get that done. But given that he's up tomorrow, I will speak to the attorney that's assigned to the PCC if there's anything that we need to get to the courts regarding this. I will do work on that. And again, I apologize to Mr. Howard.
Sure, he appreciates that, but maybe he should apologize to all the people that were waiting for him since October. January 7th, 2026, 9 a.m. We'll continue as denied. Court calls case People versus
Judge not impressed.
Sincere Godwin.
Good afternoon, Assistant Public Defender Lawrence Kearney on behalf of Mr. Godwin. Mr. Godwin, state your name for the record, please.
Sincere Godwin.
Oh, here he is.
Okay, there you go.
Sorry to wake you.
All right.
Your Honor, I'm asking for a brief adjournment. Mr. Godwin and I were playing a little bit of phone tag. So I just want to be able to touch base with him.
Adjourn this January 7th, 2026, 9 a.m. Bond continued. Thank you. Court does call the case of the People versus Kawandake Thomas.
Ashley Feltus for the people.
Public Defender Natalie Pate with on behalf of Ms. Thomas, who stands to my right. Please state your name for the record, ma'am.
Kiwana Cynthia Rose Thomas.
Thank you.
Thank you, Your Honor. I have two requests. One would be for an adjournment. We have been able to go over the police report in this case, but we need some more time to go over the media.
I think we're...
And my second request is I do believe that Ms. Thomas has released to treatments on her felony file, so I'm just asking if the court would allow a release to inpatient treatment on this case.
Babies need to eat.
All right. Yes, with a GPS tether. So I will sign that order.
Doing an ear exam.
Absolutely,
Adjourn this matter out to January 7th, 2026, 9 a.m.
Thank you very much, Your Honor.
Thank you.
Baby's happy. I'm happy. I'm fine with that.
Court does call the case People versus Tony Gomez.
For the people.
Okay. Warren County on behalf of Mr. Gomez. Mr. Gomez, state your name for the record, please.
This has just been a wild day.
Checked in. Wow.
We're so close to resolving this case, Judge.
Yeah.
Yeah. Sorry, my emotions got the better of me. I just really want.
Oh, it could have been worse.
I just really want Mr. Gomez to make it into Veterans Treatment Court. So I guess I'd ask for an adjournment for the record.
Bench warrant.
Oh, he's not here.
He's not here.
$7,500. I'll give a 10% privilege. That warrant will issue immediately. I know, because we're all set to do it.
I don't know who.
Court does call the case People versus Matthew Wallace.
Conrad Stone on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Wallace. Mr. Wallace, state your name for the record, please.
Matthew Wallace.
Your Honor, we're requesting adjournments in all three cases. We're working out a global resolution at circuit court. We think we're pretty close to that. So just requesting adjournment.
I don't mind giving the adjournment for that purpose. When's his next? I mean, when do you think that'd be resolved in circuit? So
bit of a complicating factor is he was arraigned on a new case yesterday.
That does complicate things.
That's kind of a late add-on to that needs to be worked out. He's scheduled to be seen by Judge Conlon this afternoon. So I assume that's going to be adjourned out a couple of weeks.
it's a new case he was arraigned on. Did that get set for, is that a felony?
Yeah.
It gets set for a PC.
Yes, I
When
believe.
is that one set?
24th. I want to say the 24th of December.
I'm sorry?
December 24th, I believe.
Or the
23rd. Or the 23rd.
Third? Did they say, okay, so they said
23rd.
the 23rd.
Yeah.
Okay. All right, let's do this then.
Yeah.
I'll set this one then as close to that one as I can, and if they adjourn that other one out, we may time this up.
What just happened? We just lost everything. Wait for it. I think they panicked. Let's see. There we go. Let's go to 2.
And if they adjourn that other one out, we may time this up.
Yeah, they panicked. I think what happened was somebody was worried about the baby incident. Not a problem on YouTube's terms of service, just FYI. That does not violate anything. So, glitch in the matrix. Everything froze. Imagine the court panicked and thought maybe they might be in a problematic situation, but I don't think they are. Some things are protected by law, and babies eating is one of them in most states. So, all right, we've got to see April. April still has to get to the courthouse. She's got some traveling to do to get there. I think it's probably time for us to go to lunch, but I want to see how Lindsay ends, because she's like the happiest person to ever be in court. Yeah, he does this all the time now. Did they leave to go get April? I think the defender's office put something together to get her here. These Brady Bunch streams yield so much. There has been a lot that's happened today. How many illegal things today? Yes, federally protected. There you go. Federally protected. April's coming in. Yes, she's been ordered to show up. I think there's going to be a drug test involved. I don't know if the drug test can catch the aerosol in the system and how long that lasts. I don't know if there's other indicators from huffing. It does appear based on her behavior now, looking back, we just thought she was just having fun, but based on her behavior and then the aerosol can in her hand and how she's holding and everything else, there was some use and abuse going on during that. The judge's live stream is down temporarily. Stop that. There's no testing for huffing. There might be something else in the system, though. I think that would probably be what he's looking for. Did they send cops to pick her up? What's happening with April? The judge didn't make an order. It would be a bench warrant and then order it to be, ask them to execute it immediately. I don't think he did that. But I think what we'll do is, because it's 12:31, we're going to go to lunch. If the judge comes back, we're going to try to catch that for us and see how some of our favorites that we've been watching this morning are going to, wrap up. But 12:30, give us at least half hour for lunch. Does that work? It's been a day. Tomorrow we expect to have the Brian Walsh sentencing unless it gets delayed again. And tomorrow's also the podcast. And I don't know, we might have a hearing this afternoon we're able to go to. We'll see what happens here. Anything else? Anything else we need to cover before we take a break? Today's been quite entertaining. Josh says I need 45 minutes. We'll do an hour then, Judge. We'll go to lunch and then finish off the docket later. This has been fun. It's been great. It's been a while since we were court hopping. We've had a couple big cases lately to follow. So, testing a complete blood count, determination of electrolyte, phosphorus, calcium levels, acid-base assessment, hepatic and renal profiles, and cardiac and muscle enzyme. That's a pretty thorough panel. I'm not sure if they're going to do everything. Moment of levity, anyone? Baby's not hungry anymore. So there's always that. Baby's happy. I'm just watching to see if Judge Simpson's live stream gets brought back. So far, no. I'm sure he has somebody that just watches Zoom, right? That just watches the connections, because they caught the lady with the aerosol, and he's caught other things in the past of somebody saying something obviously is easy to catch. But Judge Josh should be the new. Yeah, you need to change your name, Josh. We could call you Judge Josh. Oh yeah. Have fun, Allie B. If that's what you're looking for, enjoy it. All right, we got a lunch break, and I guess we need it. So, Simpson's back. Judge Cedric Simpson YouTube. I'm not seeing him back yet. Of course, my device is slow to recover. There he is. He is back. Do we want to keep watching until it ends? Let's see. I think we have to wait. We have to wait. Okay.
I'm here.
Sorry. False alarm.
Lighting. Wow.
Sir, can you please state your full name for the court?
James Hagan.
Thank you, Your Honor. I'm requesting an adjournment. I believe this case eventually, but I need to have another conversation with Mr. Hagan first.
I'll adjourn it January 21st, 2025, 26, 9 a.m. Bond continued.
I apologize. Or that's 21st. Okay, thank you. Thank you, Mr. Hagan.
Court calls case People versus Maya Hines.
I just felt this with people. Good.
Ms. Hines. Ms. Hines, state your name for the record if you can. I will say I spoke with Ms. Hines this morning. She's also very ill. She said she can barely speak, so I said I would do speaking for her. Because of that, we're deciding for adjournment. We do think we're close to a resolution. Ms. Hines is just really ill.
I'll adjourn it to January 21st, 2026, 9 a.m. All right. Ms. Hines, feel better. Bond continue. Court calls case of the people versus Devontae Johnson.
Felt this for the people.
Yes.
Devontae.
And Assistant Public Defender Natalie Pate on behalf of Mr. Johnson, who appears on Zoom. Sir, can you please state your full name for the court?
Devontae Johnson.
Baby's hungry again. Sorry.
Your Honor should be in receipt of
I am. I have a plea form that indicates the defendant is going to plead to retail fraud, guilty to retail fraud, 3rd degree, 93-day misdemeanor. Upon a successful plea to that charge, count 1, the retail fraud 2nd degree would be dismissed. The defendant in this case is also agreeing to make restitution in the amount of $732.82 to Dick's Sporting Goods jointly and severally with the co-defendant. That's the court's full understanding of the issue.
Dick's
That is correct, Your Honor. That is correct in our understanding as well, Your Honor.
Mr. Johnson, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name for the record again.
Devontae Johnson.
You understand that by pleading, you can put your hand out. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud in the 3rd degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that could become the maximum fine. Do you understand that, sir?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
You signed an advice of rights form or had it signed on your behalf?
Yes, sir.
Any questions regarding any of those rights?
Yes, sir.
Please look at paragraph 5 on that form if you have a copy. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as other rights contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
Yes, sir.
Okay, were you on probation or parole in March of this year?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
March 3rd, 2025, at the location of Dick's Sporting Goods on Laurel Road, I do believe, in Pittsfield Township, Washtenaw County, State of Michigan. What do you do that makes you think that you're guilty of this offense?
I went in the store and took merchandise that didn't belong to me.
And you tried to walk out of the store without paying for it?
Yes, sir.
The store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take this property, did you?
No, sir.
And this property that you took was property that was offered for sale by Dick's Sporting Goods?
Yes, sir.
Sir, if I accept your plea and you commit misconduct between the time I accept your plea and the time of sentencing, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
Or satisfied.
Yes.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be January 28th, 2026 at 12 noon. All right. Bond will continue. Sir, wait on the line. I'm going to put you into a breakout room with my probation department so we can get the process started.
Okay, thank you.
Thank you.
Thanks, Mr. Johnson.
Court calls case, People versus Mohammed Kahala.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Kahala, who should be present on Zoom.
There it is. Got it.
Sir, can you please state your name?
How's it going?
Mohammed
State your
Kahala.
name. Thank you.
Thank you, Your Honor. I have been able to review all the discovery with my client, and at this time, we're asking to set the case for final settlement conference.
Jury final settlement conference will be set for February 6, 2026 at 9 a.m. Jury selection, if necessary, February 9, 2026, 8:30. Both of those proceedings are in-person proceedings.
Okay.
All right. Thank you. Bond continued.
Thank you, Your Honor. Thanks, Mr. Kahala.
Court calls case, People versus Lerone Kelsey.
Bye-bye.
Bye.
Good afternoon, Mr. Public Defender Laura Perry.
Here, Your Honor.
So Kelsey is at work as well.
State your name, sir.
Lerone Kelsey.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of operating while visibly impaired. That's count 3, the 93-day offense. Upon a successful plea to that charge, count 1, operating while intoxicated, and count 2, operating without security, would be dismissed. There is an agreement that the case will be transferred to 36 District Court or District Court Sobriety Court.
Yes, Your Honor.
That's the court's full understanding.
Ours as well, Your Honor.
All right. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, Your Honor.
State your name for the record.
Lerone Kelsey.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
All right. And understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You had signed or had cause signed a advice of rights on your behalf. Is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Looking at paragraph 5, those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as other rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes. Probation.
Were you on probation at the time of this offense in February?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes.
February 7th, 2025, at the location of US 23 near I-94 in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
I had wine, and I probably had like 4 glasses before I went to work that night.
All right. Were you stopped by the police or was there an accident?
I was stopped by the police. There was no accident.
Why did they stop you?
I'm sorry.
Why did they stop you?
I just don't remember.
Driving.
Pardon?
Driving, Your Honor.
Driving. Erratic driving.
Yes.
All right. You're not disputing the right of the police to stop you in this case, are you?
No.
All right. After they stopped you, were you ultimately arrested?
Yes.
All right. Were you taken to the hospital for a blood draw?
Yes.
Do you recall what the results of that blood draw were?
I believe it was 1.17.
No.
Maybe 138 or 137, I'm sorry.
Yes.
0.137.
All right. And Ms. Fernie, you stipulate to that?
We do, Your Honor.
All right. You don't have any reason to dispute those blood test results, do you, sir?
No, Your Honor.
No, sounds about right.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. Sir, if I accept your plea between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes. Yes.
Counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rule?
People are satisfied.
Satisfied, Judge.
Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed.
And Your Honor, Mr. Kelsey did do an assessment with 36 District Court. I will communicate with Ms. Falara to see if that's satisfactory, if we can use that assessment that he already did, since he's already fled there and is on probation there.
All right. What I will do is I still will, for my purposes, refer him to Von Swartz for an alcohol screening and assessment. And the victim's impact panel sentencing in this case will be
January 28th at noon.
we'll probably get him done. Well, we'll do it the 28th. If Teresa or Ms. Valera moves it up, that's fine with the court. January 28th, 2026, 12 noon. All right.
We have 2 babies. They're
Sir,
competing.
I want you to stay on the line. Your bond will continue. We're going to put you into a breakout room with my probation department to get this matter moving forward, okay?
Okay. So, Your Honor,
Thank
while
you.
I have probation. Okay.
Will you what?
Well, I have probation with you guys for it. I ain't gonna say this out loud.
Well, likely not. Likely your case is going to get transferred to 36 sobriety court.
Okay.
All right. Thank you.
Yes. Thank you.
Court calls the case. People versus Austin Knox. Arraignment without counsel.
Yes.
Your name, sir?
Austin James Knox.
All right, Mr. Knox, you are before the court on a 4-count complaint, misdemeanor complaint. You understand that, sir?
Yes.
All right. All right. The complaint in this case alleges that on or about February 24th, 2025, the location, Pittsfield Township, I don't have the specifics, actually, at the location of 3688 Colt Drive in Pittsfield Township, Washtenaw County, state of Michigan. Count 1 alleges that on that date, that you did take, hold, or conceal or destroy mail addressed to another person, that being Chong Chow. You understand the nature of that charge, sir?
Yes.
That's a misdemeanor punishable by up to 1 year incarceration, a $500 fine plus court costs. You understand the maximum penalty. Count 2 alleges the same offense with regard to mail addressed to Paula Davis. Do you understand that charge, sir?
Yes.
That's also a misdemeanor as indicated, punishable by up to 1 year incarceration, a $500 fine plus court cost. Count 3 alleges that same offense with mail addressed to a person by the name of Rosa Gomez. Do you understand that charge, sir?
Yes.
That's a misdemeanor, 1 year, $500 fine plus court costs. Count 4 alleges the same offense regarding mail of an Alexandria Kelly. You understand that charge, sir?
Yes.
Misdemeanor, punishable by up to 1 year, $500 fine plus court costs. You understand that, sir?
Yes.
First question I have for you is, do you want to be represented by an attorney?
Yes.
This is a public defender case.
Public defender number 8, excuse me, sir. With on behalf of Mr. Knox, we would waive any further reading of the complaint. My client stands mute, and we would ask for an adjourned pretrial date as well as a PR bond, please, Your Honor.
Defendant having waived for all reading, standing mute, court will enter a not guilty plea as to all charges. I will adjourn this matter to January 7th, 2026, 9 a.m. The bond in this case, I will set his bond.
I think Kayla's baby went down for a nap.
I'll set his bond at a $10,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of any weapons or illegal drugs. You understand that, sir?
Yes.
I will also indicate there's to be no possession of any consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes.
I'm further going to order no contact with any of the named victims in this case. You understand that, sir?
Yes, Your Honor.
Is there any reason you need to go anywhere near or be near Colt Drive in Pittsfield Township?
I don't even remember where that is.
I don't even know.
So no.
All right, I'm going to indicate defendant not to go to Colt Drive in Pittsfield Township. Sir, if I sent you over for a drug test today, you going to pass?
I have my medical marijuana card. THC is the only thing I will not pass for.
That's the only thing in your system?
Yep. The only thing in my system, Your Honor.
I'm going to order that the defendant is to report to community corrections for weekly drug testing. He's to go take a test today.
Don't lie to the judge.
Doesn't cost anything.
Yeah, you don't have anybody.
Understood. So before you leave these premises, you need to go over to community corrections and take a drug test. You understand that, sir?
Yes.
All right. Thank you. Court calls the case of the People versus Lindsay Kohler.
Lindsay. Lindsay's
Kohler.
He says Kohler like I say Kohler.
Thank you, Judge.
Ma'am, can you please state your name for the record?
Lindsay Marie Kohler.
Hey, you're going to need to speak up. You
Lindsay
said
Kohler?
faint, something. Thank you. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading guilty to the charge of operating while visibly impaired, the 93-day misdemeanor. Upon her successful plea to that count 2, count 1 would be dismissed. That's the court's full understanding of the plea agreement.
Yes, Your Honor. That is correct, Your Honor.
Ma'am, please raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I swear.
State your name for the record again, please.
Lindsay Kohler.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, a $300 fine plus court costs. The court could also order that community service or any rehabilitation the court deems necessary, could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Understood.
All right. Do you still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form or had one caused to be signed on your behalf?
Please ask that again.
Pardon?
What was that, please?
You either signed an advice of rights form or caused your attorney to sign one on your behalf. Is that correct?
Yes.
All right. Do you have any questions regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form if you have it. Those are your rights
Yes.
which are part of a trial. You understand that you're waiving or giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily and of your own free will?
Correct.
And also because you believe that you're guilty of this offense?
Correct.
August 27, 2024, at the location of Merritt Road near Carpenter Road, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Correct.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Correct.
What did you have and how much?
A few drinks like IPA or stouts that evening.
All right, were you stopped by the police or was there an accident?
Neither. I ran out of gas and I showed back up to my car.
All right. Had you also smoked marijuana that night or taken THC in some fashion?
Oh, wait. Yes, always. Yeah, which I also have I'm getting my card as well.
But you didn't have one.
The police arrived at the scene?
Yes, I was away from my van and I showed back up to it to maybe go get more gas. I was having help and there was just a bunch of police around the van.
Were you ultimately arrested?
Yes.
You're not disputing the right of the police to arrest you in this instance, are you?
I'm not trying to, no.
Pardon?
No.
No.
All right. Were you taken to the police station or taken to the hospital for a breath or blood test?
The hospital, then the police.
All right. What were the results? You had a blood test at the hospital. What were the results of your blood test?
If I asked, it was like 0.16.
Yes, Your Honor, that defense would stipulate to that.
All right. Do you have any reason to dispute those blood test results?
No.
No? Did your blood test results also show the presence of THC and or its derivative?
I didn't ask those questions, sir. I don't know. I was focused on alcohol.
Defense would stipulate that there was the THC in the system, Your Honor, the blood test result.
10 nanograms of active delta-9, Your Honor.
Thank you. Ma'am, taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol and maybe your ingestion of marijuana?
Yes.
I didn't hear you.
Yes.
All right. Ma'am, if I accept your plea, do I have to advise you if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, that you would not be permitted to withdraw your plea, and any sentence recommendation or evaluation the court would no longer be bound by. You understand that?
Understood.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court?
People are satisfied.
Yes. Yes. Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed.
Thank you, Chair.
I was going to go get gas, but then I got high.
To Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this case will be January 28, 2026, 12 noon. All right, thank you. Ma'am, you'll need to wait on the line. I'm going to put you into a breakout room with my probation department so we can get the sentencing process started. Thank you.
Understood. Thank you.
Gonna fill up my
Court
car
calls
real
case
fast.
versus Rodney
and then I
Allen.
got high.
Or I'm sorry, Rodney Lilly.
Yeah.
An Assistant Public Defender Natalie Playboy on behalf of Mr. Lilly,
not
present on
justifying her,
Zoom. Please,
but-
sir, can you please unmute and state your name for the court?
The cops didn't see her driving.
Go ahead. Rodney Lilly.
Got it. I have a plea form. Is that what we're doing?
Yes, Your Honor.
Where's Fred?
Your Honor, is Your Honor also in receipt of a police report?
Is this the one that came in late?
Yes.
Yes.
Why are
It
you
was,
late?
Your Honor. I do apologize.
I don't. I do. This court's understanding is that the defendant will be pleading, I'm presuming, no contest
Yes, Your Honor.
to the charge of false or failure to report an accident, a 90-day offense. Upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
That is correct, Your Honor.
Sir, please.
We'll note for the record, I'm sorry, Your Honor, I don't mean to interrupt, but that there's likely to be a restitution request, so we are going to object to immediate sentencing.
Understood.
What?
Did they have, you had a question on that?
No, sorry.
Well, who are you?
My wife's sitting beside me. Sorry.
All right. Sir?
Look at the look.
Yes,
oh, my
sir.
goodness.
You've heard the agreement?
Yes, sir.
All right. Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir. I
State
did.
your name again for the record, please.
Rodney Lilly.
All right, you can put your hand down. Sir, it's this court's understanding that you're going to be pleading no contest to the charge of failure to report an accident. That is a misdemeanor punishable by up to 90 days in jail, a $100 fine plus court costs. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
Two things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Basis of the no contest plea.
Potential civil liability.
Sir, to that charge, how do you plead?
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form or had one caused or had someone or caused one to be signed on your behalf, sir?
Yes, sir.
You have any question regarding any of those rights?
No, sir.
Noting paragraph 5, you understand that those are your trial rights and that you're giving up those rights as well as all the rights that are contained on that form.
Yes, sir.
You understand you're giving up your right to appeal upright.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
You're doing this voluntarily?
Lindsay came back.
Yes, sir.
Of your own free will?
Yes, sir.
Enrique's doing
Court
it.
has been provided and has been able to review Michigan
Self-care.
Department of State Police report for their incident number 619825. Any objection to the court having reviewed that report?
No, Your Honor.
No.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
I am not, Your Honor.
No.
And have I complied with the court?
The people are satisfied.
Yes.
Court will accept the defendant's no contest plea to Count 2. Count 1 is dismissed. Defendant is referred to probation for pre-sentence investigation and report and determination of any restitution. Sentencing in this matter will be January 28th, 2026, 12 noon. Bond will continue. Mr. Lilly, I need you to wait online.
Yes,
And
sir.
I'm going to put you into a breakout room with my probation department. Understood?
Yes, sir.
Thank you. Court calls case, People versus Gregory Lockridge.
Actually felt this for the people.
Attorney Warren Attorney on behalf of Mr. Lockridge. Mr. Lockridge, state your name for the record, please.
She here.
Yeah, he's right here on
Gregory
top.
Lockridge.
Thank you.
Hoping to get some documentation for my client over to the people.
During this matter to January 21st, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Must be frustrating to sit there all morning and
Court calls
just
case, People versus
get 15
Elizabeth
seconds
Lohman.
of judge time.
People.
Got it. Hello.
Hello,
What's your name?
Elizabeth Loman.
Sloman, you are here before the court on a misdemeanor complaint, a one-count misdemeanor complaint that alleges that on or about March 23rd, 2025, at the location of 5450 Carpenter Road in Pittsfield Township, Washington County, State of Michigan, that you
It's
as
close
an
to the mellow
employee or
yellow.
agent did commit the offense of embezzlement less than $200 or more, but less than $1,000. You understand the nature of that charge?
Yes, Your Honor.
All right. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that becomes the maximum fine. You understand that?
Yes.
All right. First question I have for you is, do you wish to be represented by counsel?
Yes.
All right,
Yes.
public defender, right?
Public
here.
defender.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Lohman. Your Honor, do we have any, further reading? My client stands mute, request an adjourned pretrial date. And I do have a brief request as to bond. I did have the opportunity to speak to Mr. Lohman or Ms. Lohman prior to her arraignment today, and she's here with her father. They indicate to me that she actually resides in Florida. So I would ask for.
Does that explain the pink and green that's on her scarf?
It might. So I would ask for permission for her to stay in Florida.
She stays in Florida?
That's yes.
Is that, you're in school in Florida?
Yes, and I work as well.
Or you're in school, and you just happen to have a job,
Oh, yeah.
right?
Yes.
Kayla's moved all the way up to second
And then
position.
having waived forward reading, standing mute, court will enter a not guilty plea.
I think the baby's sleeping. You guys be quiet.
Pre-trial. All right. When are you going back to Florida?
Right now.
Thursday.
Well, when I say so, but when?
Tomorrow.
Oh, Thursday.
So, I hear you, Dad. I hear you. The whole dad telecommunication thing's going on. He just sending stuff in my head. So you're not going to be up here for the holidays. You're going to be down there.
Yes.
And then when does school start back up for you?
January
January
10th.
You have no idea, do you?
Well, no, that's the new semester starting.
Is it January 10th?
Yes.
All right, what I'll do is let me put this out there to January 21st, 2026, 9 a.m. Or is your invite in? Set her bond at a $7,500 personal recognizance bond. all other standard conditions, including no assaultive behavior or possession of any weapons or ammunition. You understand that, young lady?
Yes.
There should be no use of alcohol, recreational marijuana, or any illegal drugs. You understand that?
Yes.
I'm also going to indicate that you're not to enter any Sam's Club in the state of Michigan, or if I'm going to allow you to go to Florida, the state of Florida. You understand that?
Yes.
That's outside of your jurisdiction, Judge.
Where are you in school?
Broward College.
What year?
That I start?
We'll go again.
How far along in
What
school?
year are you?
2000.
Okay. No. Back up. Freshman, sophomore.
Oh, this is my first.
It's your first year?
Yes.
So this past semester was your first semester?
Yes.
How were you finished up?
Almost, yeah.
What's almost mean?
Like you
Finals
mean,
week.
have I finished?
Do you did you take your finals? Man, this is gonna be long.
No, not yet.
Huh?
No.
You haven't taken your finals? When are your finals? They're after the holiday.
Yes.
Are they? You have no idea, do you?
No, they are after the holidays.
They're after the holidays.
Yes.
And what will your grades be?
Who does the final after
A's?
a break like that?
All A's?
Yeah, maybe a B, but yeah. All
Snuck
A's.
that in. You told me all A's first. Now you're telling me there's going to be a B. What's the B in?
Criminal justice.
Maybe
Computer.
the B. What?
Computer.
How old are you?
19.
How do you not know how to use a computer?
I do. Varies.
They're hard. New AI technology and everything these days. I'm getting
So if I said you need to provide your transcript, yeah, I'm going to see all A's. Don't. Yeah. Probably the same answer she gives her dad. Well,
I'm getting a degree in
what am I
computer.
going to see in terms of your
Kayla's
grades?
laughing.
All A's.
Kayla doesn't believe it.
When it's available, I want a copy of your transcript. I will make a note. I expect to see all A's.
Okay.
You need to understand something. I'm going to treat you like I do my kids. If a B shows up, we're going to have a problem.
Okay.
All right? And when you say an A, I wanted to know, like, it's a 4-point if that's the scale you're on. If you come in with a rounded up
3.95.
3.95, I'm going to ask where my other 5 is.
Okay.
Are we understood?
Yes.
Because something tells me I don't know why I think you shouldn't be here. Did you grow up in this area?
Yes.
Where?
Romulus.
Something's off. The judge can smell it.
Right. I'm gonna leave. I don't have to give you a drug test, do I?
No.
She says no. I'll let her go. All right. Dad, anything else she's doing wrong you want me to take care of?
Thanks for asking, Your Honor. She's doing the best she can. I'm a single parent, full cousin.
Got it.
I had her since she was 5.
You all right? What's wrong?
Tissues. Free
What's
tissues.
wrong, young lady? I'm gonna try to guess, okay?
He's a good guesser.
Between you and your dad, right? And sometimes it's probably just made a way for you out of no way, right? And you know that. You know that sometimes it was tough, but he was always there with you, right? I'm going to suggest, not presuming your guilt of this or anything like that, that you probably did, by being here, you probably did one of the things that you most in the world did not want to do, and that was to let him down. Am I right?
Yes.
Okay. What I want you to do. Would you just take a deep breath, okay? And I know you realize this, but I'm just going to say it out loud. I don't know your dad, but everybody thinks that when I'm up here handling the case, I'm not paying attention to what's going on. I've been watching you two for a while, okay, in the courtroom. Partly because your dad looked a little shifty, but no, I'm kidding. All right, but I've been watching you two. And I'm going to tell you something that I think I just have a feeling. That man loves you more than life itself. And that I also believe, and again, I don't know your dad, but nothing will stop that ever. Okay? I know that. I can just tell by the look in his eyes that that's the case. Okay? And young lady, you're blessed, because I'll tell you something else there, and I can't explain it. I don't know what it is, but there is this bond between a father and his daughter that is something else. And even as dads, we don't understand that. Mine's a little bit older, but I got one just like you. Okay? So, in terms of that, he's going to love you. He's not going to give up on you, and I have a feeling that however this goes, he's going to be there every step of the way with you. There is not a doubt in my mind about that. And I think in your heart, you know that too. Right?
Yes.
Okay. You all right?
Yeah.
All right. You know, you gonna fall out. You got to get out that door. You do. You hear me? Okay. All right, young lady. And I do have to ask, because does the color in your scarf mean something?
No.
No, in your.
Oh, this one? Oh, no.
It doesn't? Okay, someday when you're at school, it might. All right, but I'm not gonna venture into it. Maybe your dad will tell you. I'm sure he probably will. All right. Anything else on this?
Your Honor, just to confirm, she is allowed to go to Florida.
Oh, I never did answer that. Didn't I? No, I didn't.
Juan Carlos was teared up as well.
You go.
You're good to go.
I hope it's a snowstorm. No, I'm just because we're going to be cold, you're going to be warm. Yes, you may go to Florida. Lady, take care of yourself. Do right, and no one ever defines who we really are. You hear me? All right, take care.
No one act ever defines who
Yeah, take care of yourself, sir.
Thank you, sir. God bless you.
Court calls case, People versus Elijah Matthews.
Ashes Feltus for the people.
Good afternoon, Assistant Public Defender Lauren County on behalf of Mr. Matthews. Mr. Matthews, state your name for the record.
Oh, there he is.
Elijah Matthews.
I've got a fine
We
beard.
are requesting an adjournment. It's another case that I need to make a discovery request for the people. So I'll be getting in touch with them.
Adjourn this matter January 21st, 2026, 9 a.m.
He's been here for 2 hours waiting for that.
All right, thank you, sir. So it's 11, it's 12. All right, I'm going to take a short break. We're running behind, and that's because of something that was a little bit beyond my control. And then I'm going to let them set up for this next block. we'll do that. We'll just keep moving. Court's going to stand in recess.
All rise.
Okay, here's what we're going to do. We're going to go to lunch, too. We're going to go to lunch. I've already played the music once. I have to do it again. So, Mrs. R.A.'s here. I'm going to go take the car, check the tire pressure. She says it's not driving straight. So we'll do that. She has to go again tomorrow. All right. I'll keep the Simpson thing rolling because we want to see how Kayla ends, and we want to see if the babies are used effectively as to soften up the judge. We also want to see if April makes it to court. She's supposed to be arriving and taking a drug test and then facing the judge. You can't huff on camera on Zoom court. It's like smoking, only worse. So we'll be back on the flip side. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe until we go live again. In about an hour, we'll pick up after this break. I'll save all that. Kayla's getting a break from mom duties as the baby takes a nap. Enrique is just chilling in the car. Carlos and Rocio appear to be in the same place because of the color of the walls. It's all good. We'll be back after noon. Remember, tomorrow we've got the Brian Walsh sentencing happening as well as the podcast. So thank you very much. Appreciate you guys joining me for this Hump Day edition of Court Hopping. We'll be back for the afternoon for a little bit and get a little bit more, and then we'll call it a day. It's been a day. It's been a full day of all sorts of things. So you guys have good lunch. We'll see you after. Bye-bye.